So there we move to paragraph 7. Matters arising. Yes?
Yes, Madam Chair. In the first paragraph on the 7, there is the sentence which begins, the arresting officer would also have to indicate that he had no reason to oppose bail. It's assuming there. I think this sentence is not complete. It's assuming that the person would want to not oppose bail.
Which sentence is that?
The one beginning with the arresting officer. It's the 6th line.
Sixth bullet line. Point?
Under 7.
Under 7. Oh, I see.
Matters arising, and then we go to the 5th line,
right.
Which is the arresting officer.
Just give me a moment. So Member Jackson asked whether a police officer, for example, a constable who had arrested an individual for an offence, would have to get approval from an officer of a higher rank in order to grant bail. Chairman responded that an officer, after having arrested an individual, would have to make a record of it and subsequently hand the said individual over to a custody officer. The arresting officer would also have to indicate that he has no reason to oppose bail where that is the case. Yes.
So that's missing from it,
yes.
Where that is the case.
So the matters arising, please note the correction, the words where that is the case, to be added after bail, oppose bail.
Right, and then also, Madam Chair, a point that is not substantive to the Bail Act, but in general, is it's to indicate that it's not gender neutral. A decision was taken that we should be gender neutral because police officers can be females as well.
You know, that is absolutely true. We have an Interpretation Act which guides how we use terms, especially for legislative purpose, and it did indicate that the male gender include the female gender. For my purpose, I would prefer that the she be put because she contains he.
The Solicitor General, I like that thought process.
Only because, by way of wording.
But Solicitor General ruled on this in another committee, and she said even though that is in the Interpretation Act, the decision was taken by their chambers and the AG's chambers to be gender neutral throughout. So I just wanted to highlight it here.
You know, we appreciate that there are many issues around gender designation, to the point where many people now specifically put on their online profile whether they are he, him, she, her, etc. So
not looking to go that far, Madam Chair.
No, the neutrality then moves the word to the plural form when we are referring to someone single. So the use of they, for example, is regarded as gender neutral. But grammatically, I've wondered, you know, when you're referring to someone singular, to use the plural. But let's not make an issue of it, but the point is noted.
Right. What Solgen suggested, and that has happened in other committees,
he or she?
He or she.
All right. It means that we would have to go through. Sometimes it's just for ease of reference, but we would like everyone to know that referencing that way is because of how we have it in the Interpretation Act, and it is meant as no disrespect to anyone. All right. Chairman recalled the committee had requested that a letter be sent to the Court Administration Division, and the Director of Public Prosecution indicated that she had reviewed the correspondence to ensure that it accurately reflected the committee's request. Following consultation with the committee clerk, she indicated that the letter was acknowledged and a response was to be provided by January 25. All right. Move over to page 4. I think a matter arises from this. Page 4, paragraph 8, new business. Ms. Wilkins read the recommendations made by Jamaicans for Justice, JFJ. She said that the JFJ had proposed that Section 3 of the Bail Act be inserted in the bail bill to make it clear who would be entitled to bail. She further said that JFJ had submitted that the reinsertion of Section 3 would address the mischief associated with the deciding official. That is, it would remedy the confusion which could arise in relation to the role of a police officer versus that of the courts. Additionally, JFJ proposed that it must be stated that the conditions of bail, with or without surety, must be reasonable. The entity submitted that the right to bail was clearly provided for in the Constitution, and subsuming that right under Clause 6.1a, which dealt with a grant of bail after charge, would lead to confusion and would ultimately affect the flow of the bill. JFJ also submitted that the decision to subsume the right under Clause 6 might create the impression that the government viewed constitutional rights as mere privilege. The chairman stated that it was unfortunate that the JFJ would make that statement. She pointed out that the rights of Jamaicans were guaranteed under the Charter of Rights and Fundamental Freedoms. I think it's a Charter of Fundamental Rights and Freedom. Mr. Foreman, isn't that? So, yes. So let's correct to read Charter of Fundamental Rights and Freedom. She indicated that the country was challenged by a number of issues and added that the focus should be on the solutions being contemplated rather than the problems. She stated that the entity should be careful of the message it was sending because there were people who would be emboldened by it. Member Jackson responded that members of the public were usually invited to make comments on the various pieces of legislation to be reviewed by Parliament. He said that he did not want anyone to be intimidated in the future to make comments due to the chairman's statements because it was part of the democratic process. The chairman stated that comments from the public and various entities were welcomed. She reiterated that there were people who would be emboldened by certain statements, and therefore one had to be careful about what was said. Member Jackson said that entities such as the Norman Manley Law School had made enlightening submissions on the bill, and he would have wanted the committee to spend additional time reviewing the comments. However, there were time constraints. He underscored the need to spend additional time to deliberate the issues, some of which might not be evident to lawmakers. Should lawmakers be one word? I think. Lawmaker is a single word, isn't it? Yes, we can check for that. The chairman informed the committee that the various peculiarities of the Jamaican environment, as well as certain values, such as the importance placed on freedom, were taken into account when drafting the bill. She said that she was aware of the constitutional role of the Parliament in making laws. It's not to ensure, for peace. Please, instead of to ensure, is for peace, order, and good governance. It's actually good government. May I just borrow a copy of the Constitution there, just to check for accuracy? And highlighted the efforts made to enhance the legislative process. She made it clear that it was not her intent to rush the process, but as chairman, she had to ensure that the time was optimally utilized. She advised the committee that it was important to her that people understood the law and that that was one of the reasons consultation was done and the language that was used was carefully decided on. Just crave a moment to just check. Peace, yes, Peace, Order, and Good Government of Jamaica, Section 48.1. So I thought that was what I had said. Just to correct from good governance, the role of the Parliament in making laws for peace, order, and good government. All right, so 2 corrections on page 4 to change Charter of Rights and Fundamental Freedoms to Charter of Fundamental Rights and Freedom, and to change to ensure to for, and changing good governance to good government. If there is no other correction, if there are no other corrections, we move over to page 5. Member Paulwell commented that it was the first committee of which he was a part that had received so many comments from the public, and he welcomed it. He made a point that people would have divergent views and would take a different stance on various matters. He said he did not want comments, such as the one made by the chairman, that people could become emboldened by the views expressed by presenters to deter individuals from making submissions in future. The chairman responded that the government had to defend its policies, but was open to hearing the views of others. She said that people might have shared interests, but their positions on certain matters could be different. For example, she stated that people had a shared interest in ensuring that individuals who had been detained would not languish in prison. However, there might be a difference in the position on what should happen after they were taken into custody. In the ensuing discussions, Ms. Wilkins commented that provision was made for bail before charge in Clause 5 of the bill, and Clause 6 spoke to the entitlement to bail. She said that the JFJ was proposing that the entitlement be shifted to an earlier clause, namely Clause 3 of the bill. She added that in so doing, Clause 3 would encompass both pre-charge and post-charge bail. Mr. Foreman stated that he was in support of JFJ's recommendation that the entitlement should be noted in an earlier clause. He said that the right to bail was stipulated on the Charter. Again, please change Charter to Charter of Fundamental Rights and Freedom. And added that it should be clear that bail would apply in both pre-charge and post-charge situations. Member Paulwell said that the opposition was in support of the recommendation made by JFJ. Ms. Grant indicated that the provisions in the bill were crafted to reflect what obtained in the Constitution. She said that reference was made to an entitlement to bail in Section 14, subsection 4 of the Constitution, which dealt with a person awaiting trial and detained in custody. She subsequently referred to Section 14(3)(a) of the Constitution and added that in the case of a person who was arrested and detained but not yet charged, there was no reference to entitlement of bail. She pointed out that the word shall was used in that provision and added that that word had a stronger meaning than entitlement. She advised that entitlement was subject to a qualification, and therefore a person could be refused bail if it was felt that there was sufficient evidence to keep him in custody. She stated that she would recommend that Clause 5(1)(b) be amended by replacing the word may with the word shall. Clause 5(1)(b) would therefore state that the deciding official shall grant bail to the defendant on the ground of any of the matters so specified. And Ms. Wilkins said the recommendation made by Ms. Grant was consistent with the language used in Section 23 of the Constabulary Force Act, where provision was made for station bail. All right, if there is no amendment other than to Charter of Fundamental Rights and Freedom, we move to Clause 5. Grant of bail prior to charge. With respect to Clause 5, Member Paulwell stated that various presenters had expressed concerns about issues of legality and constitutionality. He mentioned the approach of the courts in interpreting various pieces of legislation in recent times as being revolutionary, and pointed out that they did not want the legislation to be struck down because it was deemed to be unconstitutional. He said that he understood that the government had tried various measures, such as states of emergencies, to stem crime, and he had supported some of the measures. However, focus should be placed on the gathering of evidence in order to apprehend criminals. He commented that the opposition would need at least a week to consider the views of the various presenters in order to make a decision regarding the provision. Member Jackson remarked that crime fighting required a collective approach, which meant that the support of the opposition was necessary. He said it was against that background that Member Paulwell had made the request. There is no amendment to that paragraph. We move to the next. The chairman indicated that she appreciated the comments made by Messrs. Paulwell and Jackson and added that any reasonable opposition would want to thoroughly review the issues. She agreed that legislators must be careful in drafting legislation, given that they would be subject to the interpretation of the judicature. She reminded members that the government would not disregard the rights of people expressed in the Constitution and added that she understood the concern that the courts could rule that a piece of legislation was unconstitutional. However, that did not mean that it was not well drafted. She said that their request for additional time to review the provision was constructive and consideration should be given to how best that could be facilitated. She later stated that the Constitution made provision for people to be detained, and therefore there was a question of what to do when people reasonably suspected of committing an offense, given that there were certain steps which had to be taken prior to their being brought to trial. So let's just correct them to their. Member Jackson stated that the legislation was based on the policy of the government and recommended that before any policy was developed, there should be thorough consultation. The chairman agreed. She later stated that Mr. Foreman had expertise in the area of constitutional law and human rights and could provide guidance. She added that the Legal Reform Department could also provide advice. Member Jackson said the opposition would consult Mr. Foreman. The chairman asked Mr. Foreman if he were prepared, let's change that was to were, for a discussion on the matter. Mr. Foreman responded that he had to do further review and would consult with the Attorney General. He later commented that it was important to review sections 14(1)(f) and 14(3) of the Charter of Fundamental Rights and Freedom. Please amend again. That was based on Article 5 of the European Convention on Human Rights, which dealt with the right to liberty and security. If there are no other corrections other than the three pointed out, we move to the next paragraph. Committee decided to take a 45 minutes break. Ms. Grant subsequently inquired whether the committee would resume the discussion at Clause 5 because there was a matter relating to Clause 5, subsection 1C, that she wanted the committee to consider. Chairman stated that the committee could consider that specific provision. The committee resumed the meeting at approximately 2 p.m. Ms. Grant said that the latter part of Clause 5.1c made reference to a judge of the parish court being able to determine bail. She pointed out that the provision should be more precise because there were factors that a judge would need to consider in order to determine bail, and Section 14, subsection 3 of the Constitution would have to be taken into account. Right? If there is no correction to that paragraph, we move over to page 7, Clause 5. Member Charles, Clause 6. Would you assist in reading through that part of the minutes, starting at Clause 6? Page 7. Please go on, Mike. Start again. Yes.
Ms. Wilkins pointed out that the Jamaica Bar Association had recommended that Clause 6, 1A, be amended to include or make reference to the circumstances under which bail could be denied and set out in Clause 7.1. Ms. Grant stated that the bill should be read as a whole, and therefore there should be no need for cross-references. Ms. Wilkins said that the association had pointed out that the term deciding official would not be defined, not be defined in the legislation?
I pointed out that the term deciding official was not defined,
in the legislation, and therefore it was not clear that a constable who was below the rank of superintendent could not be a deciding official. She added that the association had submitted that it was not certain of the intent of the provision, but it should be clear that no one below the rank of superintendent will be considered as a deciding official. Ms. Wilkins said that based on the Constabulary Force Act, it was the officer in charge of a police station or the sub-officer who would be able to make a determination regarding bail. The chairman then pointed out that no one piece of legislation operated in isolation. Member Jackson stated that some issues could be remedied if the references were to be inserted. With respect to the post-charge bail regime...
Please, let's just pause paragraph by paragraph to allow members to indicate whether any correction is to be taken. Is there any correction to that paragraph and the preceding one? If none, then we just move to the next.
With respect to the post-charge bail regime, the chairman stated that there was a reason for not stating that the officer would grant bail, who would grant bail should be at or above the rank of a superintendent. She explained that that could create administrative delays because there were stations where there was no superintendent present. Ms. Wilkins opined that it might be useful to make references to the appropriate provision in the Constabulary Force Act. The chairman pointed out that the act was scheduled for review. Ms. Grant stated that if reference were to be made to a specific provision in that act and there was a subsequent amendment, it would create an inaccuracy in the bill. The chairman said that she would provide an update as it related to that act. The chairman said that the matter would be further reviewed. However, the committee would be guided by the Chief Parliamentary Counsel.
Madam Chair?
Any correction?
Yes. In the sixth line, it started from the fifth. The chairman pointed out that it should be the second that should be the.
No, it's that act, meaning that act, the Constabulary Force Act. Pointed out that act was up for review. Yes. Yes.
I'm trying.
Right, so it has to be read to be understood.
With regard to Clause 6.2, Ms. Wilkins said that the association had recommended that the question of bail should be decided on by the police within 24 hours, especially since the offenses under the provision were not punishable by imprisonment. She said that the view was expressed by the association that 24 hours was more than reasonable for consideration to be given for granting bail. The chairman pointed out that the circumstances under which a person should be kept in custody were clearly outlined. Ms. Wilkins responded that the provision stated that the question of bail should be considered within 48 hours, and the association felt that the process should be dealt with more expeditiously. The chairman stated that there were certain administrative matters that were taken into account in deciding on the timeline. She added that the matter could be further considered by the committee.
If there is no correction to that paragraph, we can move to the next.
Jamaicans for Justice, JFJ. Ms. Wilkins noted that the JFJ has submitted that Section 6 of the Bail Act should be amended. The chairman pointed out that the Bail Act would be repealed and not amended as proposed. Ms. Wilkins further noted that JFJ had proposed that the Child Protection and Family Services Agency, CPFSA, and the offices of the Children's Advocate should ensure that children were protected. Mr. Foreman noted that reference was made by JFJ to Section 67 of the Child Care.
There is no amendment. We move to the next paragraph, over onto page 8.
And Protection Act, which dealt with bail for children. Mr. Foreman said that the JFJ was drawing attention to Section 67 of the Child Care and Protection Act in order to highlight their concerns. However, that act was not before the committee. The chairman said that this committee did not have the authority to make amendments to that piece of legislation. She further said that the concerns expressed about children in custody were valid. However, most of those who expressed concerns failed to focus on the need of children to be taken into custody for their care and protection. She stated that that was constitutional and lawful. Ms. Wilkins stated that there would have to be consultation with the various stakeholders in order for amendments to be made to the Child Care and Protection Act, and it was outside of the remit of this committee. Mr. Foreman said that Clause 3.2 of the bill dealt with bail for children. He read that section as follows.
Member Charles, I wonder if you could read a little louder.
As follows. Sorry. The questions of bail, where the defendant is a child, shall, unless otherwise provided in any act, be determined by a children's court in accordance with the Child Care and Protection Act. So, however, that subsections shall apply in respect of the provision of surety by a parent or guardian of the child.
Is that bracketed S correctly placed? Just check for accuracy there, so that that subsection shall apply. If it's a single subsection, I'm not sure why an S, intending to pluralize it. It's not there. All right, so let's just correct to that. It's just subsection. Yes. All right. If you want to be helped by Senator Rodriguez. Yes.
Senator Campbell Rodriguez proposed that the committee could submit the recommendations made by the JFJ to the requisite entity in order for it to be taken into consideration. The chairman stated that the recommendations should be reconsidered by the entity and added that it should not be submitted in the form that it was in. She recalled that at the previous meeting, the committee had requested that the Legal Reform Department respond to the requisite entities about any recommendations that was considered by the committee to be of merit, but was not required to be addressed in the bill. It was noted that JFJ further proposed that Clause 6.1 be amended to indicate that the deciding official must consider the following factors when determining sufficient cause under subsection 6.1. A, the need to secure that the defendant surrenders to custody. B, the need to prevent offending by any defendant. C, the need to safeguard victims of crime and witnesses, taking into account any vulnerabilities of any alleged victim of or alleged witnesses to the offense for which the defendant was arrested, where these vulnerabilities have been identified by the official. D, the need to safeguard the defendant, taking into account any vulnerabilities of the defendant where these vulnerabilities have been identified by the official. And E, the need to manage risks to the public.
If there is no correction, we move to the next paragraph.
The chairman said that provision was made for this in Clause 7.3 of the bill, which addressed circumstances where bail may be denied. The chairman asked Ms. Grant to comment on the recommendations. Ms. Grant responded that there could be a further review of the provision to see if there was anything that was not covered in the bill. The chairman said that the matter would be further considered.
Next paragraph. Yes, if there is no correction, I see none from my perspective.
With respect to Section 6.3, Ms. Wilkins noted that the JFJ had submitted that they should revert to the provisions of the Bail Act. It was also proposed by the entity that there should be clear limitations regarding the types of offenses for which the police could grant bail, and there should be an indication of the number of years of imprisonment for the various offenses. The chairman responded that there was clear that there were offenses for which...
That it was clear.
Sorry, that it was clear that there were offenses for which the police could not grant bail. Ms. Wilkins said that Section 6.3 of the Bail Act made references to a long list of offenses in Part 1 of the second schedule, for which only the court could grant bail. The chairman stated that the committee would not accept that recommendation. Member Jackson made references to Clause 6.3 of the bill and pointed out that it was noted that the question of bail may be considered only by a judge. The chairman responded that the use of the word may in this context was beneficial. Mr. Foreman said that the language was the same as that used in the current legislation.
Madam Chair?
Yes?
The reference to the Bail Act, both on pages 8 and 9, that last paragraph that was just made, I'm assuming it's the Bail Act 2000?
Yes.
Can we edit to show that it's 2000 because they're both called
Well,
Bail?
one is the Bail Bill 2023 and one is the Act.
I know, but someone reading the minutes, especially if you're new to the Parliament, for example, could be misunderstood because this is also labeled the Bail Act. So it's a bill now.
Okay.
But
no, you're right. But
yes.
look on what you see. Flip the other page and see if you see a bill entitled.
Yes.
Yeah.
Right, but it's there. But just for clarity, I think would be good if we just
there are some
edited
rules
it.
around this. Ms. Wilkins, can you assist us with that?
Well, there's only one act ever, so we can't. It wouldn't be proper to put the year. There's only ever one Bail Act. When it is amended or repealed and replaced, it's replaced by the Bail Act, and it's still just the Bail Act.
I understand that completely, unless it is completely wrong to do so. But I just think for someone reading the records, it could be a little misunderstanding. It could be misunderstood. But if it is completely wrong, then I...
Under what circumstances do we use the year for an Act of Parliament? I know that
Madam
issue
Chair,
arose.
Here she is.
We do so whenever the act has not yet been incorporated into the revised laws. But in this case, since the act is from 2000 and the revised laws are up to date to 2016, I believe, then we would drop out the reference to 2000.
Do forgive that delay. I was just making a note. So the rule is that when an Act of Parliament is not incorporated in the revised law, the year of enactment is used. Once it is incorporated in the revised law, the year is dropped. I can tell you that we in the ministry are looking on and will look further into all of the rules around how we publish the laws. For example, the memorandum of objects and reason appearing with it. So I take note of the little things, because the fact that we have done things a certain way, I normally like to know the year when a law was passed. What happens is that you will have amending bills which are read and construed as one with the principal act. So in due course, we will explain But the goal is always to ensure that those who interface with the law can do so with ease, as much ease as possible. But I would ask that you be guided for now that their absence of the year is deliberate because there is the act and there is the bill. Thank you, Madam CPC. Thank you, Director Legal Reform. Let's proceed.
Norman Manley Law School. Ms. Wilkins noted that the Norman Manley Law School had submitted that the bill often placed the pre-charge and post-charge defendants on the same level, removing the hierarchy between the number two categories. The law school had indicated that this was an inaccurate approach when one took into account the different statuses of the number two sets of defendants. It was further submitted that the approach was neither reasonable, proportional, nor necessary. The chairman said that a person who had not been charged was in a different category than the person who was charged. She said...
I'm sorry, the statuses, I think that's a typo. It should be statutes.
Statutes of two.
Yeah.
Where is that?
In the fourth line, when one took into account the different statuses of the two sets of defendants.
Yes, yes.
Hold on, it's not statutes.
Two.
It's status.
Statuses.
It's status, okay, sorry.
It's the status, right.
Status.
But I think it's a different status.
It's still not a word that you pluralize. You take the status of the two sets. You never pluralize status. You have a status. You don't need
Actually, I'm checking the dictionary, and it does say plural statuses. It's quite. I think it sounds awkwardly because we're not used to it, but I just check. I'm sorry? Pull it up online and see. No, not this one. Right. Yes.
If we're going to be grammatical,
all right.
you don't need to pluralize the word in this instance because it's just the way it's used.
But it just jumps out as a little odd, eh? Right. So the status, the different status. I won't make much of it. Go ahead.
The use of the word different in front of it means you don't have to pluralize it in this instance.
I am always guided by those who know more than I do. Always. On everything. Right. Go. Okay. So the different status of the two sets. Okay. Yes, please proceed.
The chairman said that a person who has not been charged was in a different category than the person who was charged. She said that both would have to be reasonably suspected of committing an offense, and that it was on that basis that a person who had been deprived of his liberty
would have been deprived of his liberty.
That person would have been deprived of his liberty. She subsequently read sections 14(1)(f) of the Constitution. Mr. Foreman stated that the recommendations made by the Norman Manley Law School seemed to be of a general one and was not in relation to Clause 6 of the bill. The chairman stated that there did not seem to be any inconsistencies with the recommendation and the general approach taken in the bill. Ms. Wilkins asked if reference should be made to the provision for the deprivation of liberty in the Memorandum of Objects and Reasons. The chairman responded that committee had agreed that the Memorandum of Objects and Reasons would be amended. Clause 7, circumstances where bail may be denied. Jamaica Bar Association.
I'm sorry? Any other correction to this paragraph? If none, we move on. And we need to move a little quicker. We're almost to there.
Ms. Wilkins noted that the Jamaica Bar Association had expressed concerns in relation to Clause 7.1b. The association had stated that there was a potential of abuse given that a police officer could deny a defendant of bail because it was impracticable to obtain sufficient information. The association therefore proposed that there should be a requirement for the deciding official to speak with the defendant in order to ascertain information needed to decide on bail. The association noted that in the absence of that, the only information or account that might be presented to the decided officer would be that of the arresting or investigating officer. Mr. Foreman stated that the proposed provision was contained in Section 4.1c of the existing Bail Act. The chairman responded that the recommendation made by the association did not take into account the hallowed principle of the judiciary system that adverse decisions would not be taken without hearing from a defendant.
Next. Yes.
Ms. Wilkins read Section 4.1c of the Bail Act verbatim and pointed out that under the provisions, specific reference was made to the court making the decision to deny bail if it was not practicable to obtain sufficient information. She said that there was a question of whether the police could be expected to act in a judicious way. The chairman responded that the police would be expected to act as required under the legislation and added that there would be a public education and special training on the provisions of the bill as was done with the Firearms Act. Member Williams stated that his understanding was that the association was requesting that a clause be inserted to impose a duty on the officer to act expeditiously. The chairman responded that there was a general duty placed on police officers to act in a timely manner and added that the Constabulary Force Act, which governed the operations of the officers, would be reviewed. She explained that there would be administrative and judicial reviews of decisions and read Clause 11, review of bail decision verbatim. The chairman said that the committee would not accept the recommendations of the association because there were safeguards in the bill to address the concerns raised.
My recollection is that before stating what we would accept or not accept, it would be based on the consensus of the discussion. And so you would note that some matters would be further reviewed and further deliberated on. So it's not just that the chairman is saying that the committee would not accept it, but the approach taken is to get a general indication from the committee, and then we move on. And that general indication also showed where we would further review a matter, where we would come back to it. Proceed, please. You want to be relieved now? All right, let me pick up. Member Rodriguez? All right, Member Rodriguez will pick up reading, and then we have to get on with the meat of the matter.
Jamaicans for Justice. With respect to Clause 7.1, Ms. Wilkins noted that the JFJ had proposed that a new paragraph be inserted. It was recommended that it should read as follows. G. Where a defendant is denied bail in accordance with subsection B or C, the deciding official has a duty to ensure that the investigation to gather information, make inquiries, or prepare the necessary reports is conducted diligently and expeditiously. Where they have failed to do so, the deciding official may be found in contempt. Should I continue? Ms. Wilkins said...
Just to remind members that when a pause is taken between paragraph, that is to allow you to indicate whether you have any correction to the paragraph, so that I do not have to intervene at every pause.
Ms. Wilkins said that the JFJ had submitted that it appeared that the negligence of a deciding official may be codified under clauses 7.1b and c, and recommended that where a deciding official failed to carry out their duties in an expeditious manner, there should be consequences for same. The chairman responded that she was in agreement that there was need for public officials to be held accountable, and added that there would be a review of the public service regulations from which the staff orders flowed. Member Jackson said that he was in agreement with the recommendation of JFJ and added it was incumbent on them as legislators to address the matter within the legislation. He further said that if it was not done, people might languish in detention. The chairman referred to Clause 5(6)(b) of the bill, which spoke to the stage of an investigation and the manner in which it was conducted. She commented that there were improvements in how cases had been handled and pointed out that there were instances where arrests were made, charges were laid, and there was a subsequent trial within a reasonable time. She questioned where it would be stated that the investigations must be done expeditiously and that a failure to do so would lead to negative consequences. She remarked that once a matter was before the courts, a judge would determine the timeline within which information should be gathered, and if there was a change in circumstances, that would be taken into account. The committee decided that the matter would be further reviewed.
To say, Madam Committee Clerk, right, there are some circumstances where the decision is of the committee. In those circumstances where we would not be accepting the recommendation earlier o'clock, it would have been the committee's decision. There were somewhere it's the chairman's decision to say we would come back to it. So please note for amendment. Yes, please proceed.
The sentence that starts with Member Jackson said that he was in agreement with the recommendation of JFJ and added it was incumbent on them as legislators.
On us?
It should be us, not them.
Yes.
Okay, next paragraph. Ms. Wilkins noted that JFJ had submitted that Clause 7(2) of the bill, which dealt with murder within zones of special operations, be repealed. The JFJ pointed out that the strength of the evidence that a defendant committed an offense was provided for under Clause 7(3)(g), and therefore they did not see the need for the additional punitive measure in Clause 7(2). It was further pointed out that the considerations under subclause 3 would more likely allow for bail to be considered on a case-by-case basis without the limitation that subsection 2 would place on that discretion. The chairman stated that the murder rate in Jamaica was very high and the government was of the view that the abnormal level must be addressed with urgent measures. She said that Azosa was not an ordinary police operation, and where murder was committed under these operations, it should be seen as a blatant disregard for the law. She noted that more severe penalties for murder was being considered, and the number of years which would be allowed to pass before consideration would be given to parole would be extended. Member Jackson said that no one was saying that the high murder rate must be deemed tolerable. However, the focus should not be on the numbers. He said that even one murder was too much, and the message which should be sent was that murder should never be tolerated. Senator Campbell Rodriguez opined that a response to a crisis would be determined by the severity of that crisis. She made reference to a Category 5 hurricane and pointed out that Jamaica's crime problem was like a hurricane of that magnitude, and therefore the response to it must be adequate to deal with the gravity of the situation. Later in the discussion, the chairman said there seemed to be a divergence of views as it related to how crime should be tackled. She said that murder was seen by the opposition as being normalized at a certain level, above 1,200 per annum. However, the government had a different perspective and had therefore implemented certain emergency measures. She stated that there was a need for dialogue to consider the situation. Member Jackson said that the opposition had been calling for dialogue. He added that it was not only the government that viewed crime as being intolerable. The chairman mentioned the recommendation made by the JFJ and added that a person who had committed a crime under Azosa was brazen and therefore bail for such an individual should be denied. Member Williams questioned the policy intent of the provision. He said that he understood the point being made by the chairman as well as JFJ's proposal. He pointed out that a deciding official would have to assess a case to determine the strength of the evidence before denying bail. He said that there could be a case of mistaken identity and questioned what would happen in a case where the evidence was questionable and the judge was not satisfied with what had been presented. He suggested that the matter be further reviewed by the committee. The chairman asked Ms. Grant to comment on the recommendation by JFJ. Ms. Grant responded that notwithstanding what had been said by the entity about the nature and seriousness of an offence in Clause 7.3g of the bill, the intent was to highlight examples of matters which could constitute reasons to deny bail. She said that consideration could be given to reversing the orders of the provision, and therefore subclause 3 would become subclause 2, and what was contained in subclause 2 would become subclause 3, and would commence with the words, for the purposes of subsections 1 and 2. As it relates...
I think that 1 is to be written as a numeral 1 when you're referring to subsections. Numeral 1 and numeral 2, not the Roman I and double I.
As it relates to the recommendation made about Clause 6.1a, Ms. Grant said that in order to tie everything together, the following words would be added at the end, having regard to the matters specified in Clause 7.1 to 4. The chairman said that 2 of the recommendations of the JFJ would be accepted in part. The committee decided it would conclude the discussions at that point. Closing remarks. The chairman stated that the next 2 meetings would be held on January 26, 2023 at 2 p.m. and February 1, 2023 at 10 a.m. Any other business? There was no other business. Date of the next meeting was scheduled for Thursday, January 26, 2023 at 2 p.m. Adjournment. There being no other business, the meeting adjourned at 4:30 p.m. on a motion by Member Paulwell and seconded by Senator Campbell Rodriguez.
This has taken us just short of an hour to review, but I thought it helpful since time had lapsed between our last meeting. But I know that this is not the last minutes of the last meeting. Well, so January 26th meeting was not held? So just, all right, we'll come to that. If there be no other correction than those noted, can we move for the confirmation of the minutes as Member Rodriguez Campbell Rodriguez? Member Michelle Charles. Matters arising. All right, let me just start with the last one. The date and meeting of the next meeting, Thursday, January 26th at 2 p.m. Madam Clerk, can you just remind what happened?
The host was sitting on that day, and we never had a meeting, neither on the 26th or the 1st.
Very well. So just to make sense for the next minute is that though the next meeting of the committee was scheduled for January 26 and February 1, the meetings of the host displaced those proposed meetings because we didn't have facilities to meet, right? Very well. I think may I just ask committee members, any matter arising from your end?
Madam Chair.
Morning. Good afternoon.
Morning.
Good afternoon,
Yeah.
Member Scott Motley.
Oh, it's afternoon already. I actually wanted to ask a question, Madam Chair. I'm trying to adjust my camera. And that is in relation to the schedule and the notation where only a judge can grant bail for certain offenses. And I wanted to ask you, Madam Chair, what is so egregious about the provision under the law reform, the Zozo Act, that if you don't state your identity or you give a false identity, that is an offense which can only be where only a judge can grant bail? The penalty is a fine of $100,000, or if the fine is not paid, imprisonment for 10 days. I just wanted to understand the thinking behind its inclusion.
Can I just ask, the reference you made to the penalty, what is your thinking around that by joining the two? The penalty is what it is. I'm just trying to clarify something in my mind.
If you look at all, I'm sorry, I'm having a little problem with if you look at all the other offenses, they are of a particular nature.
Yes.
The Act has said that they were offenses punishable by imprisonment. This offense seems to me to be where a fine is imposed. And as always, imprisonment is in the alternative. So if you don't pay the fine, you're imprisoned for 10 days. So I wanted to understand why it was that this particular offense fell under the schedule and under the section that says only a judge can grant bail. That was what I was asking.
I appreciate the question. I know we have, let me just ask the team to remind me, either Ms. Wilkins or Madam CPC, Ms. Grant. I'm just trying to ensure it's not an error before I respond, because I know there is a particular peculiarity around identity.
Yes, I'm looking.
But I know we also had some errors with the schedule. Member Scott Motley, may we just stand that down to allow the team to check?
Certainly, Madam Chair,
yes,
certainly.
But an important query. Thank you for raising it. Yes. I just want to await a response as to whether there is an error or there is a deliberate inclusion before I share my thoughts on it.
Yes.
Perhaps it would be helpful, though, if the member would indicate, is there a specific offense that you've seen in the schedule for which there's just a fine?
It's at 16, number 16 of the schedule. Under the category offenses for which only a judge can grant bail. I'm bringing it up again. Have you seen it?
Yeah, I've seen it. No, an offense under Section 21 of the law reforms only. Yes. Let us check that.
Yes, yeah, I would be obliged. Thank you.
Any other matter? So offences for which an application for bail can only be made by the judge.
Madam Chair, there was one aspect. I did not attend that meeting. And even though the minutes were read, I was a little unclear as to what was the conclusion in relation to the point made by Member Jackson, where he was asking for some accountability, within the legislation. You had in fact made reference to the public management Accountability Act, PMBA. But I wondered if it was, your response was saying that no, you didn't feel that there had to be any particular note or clause in this legislation that we are looking at. Could you clarify that for me?
This is on page 6. Just point me, just remind me of the page. I know the point.
I'm using a soft copy and it keeps on.
I know the point that was made. We had spent a little time discussing it. So,
your response was to support the whole issue of accountability, but you had mentioned that particular legislation. But I wasn't sure about your conclusion as to whether that...
I'm just looking back at it because it is one of the matters that I have been...
Senator Campbell Rodriguez was the one who read that.
Oh, no. I'm fully aware of it. I'm just looking back on how it is recorded, just to say it is one of the matters that I have been thinking through since the last meeting and this one.
But Chair, there is no, as long as you're thinking through it, as I said, I was not present.
Right.
And when you're present, you have a sense of clarity about where the discussions are going. So you need not detain yourself with it. We'll come back to it then, ma'am.
Yes, no, it very well. There were 2 other matters on page 6, the comment that was made by Member Jackson that the legislation was based on policy of the government and recommended that before any policy was developed, there should be thorough consultation. I thought I would just remind that the Constitution actually gives guidance on this matter. And a lot of the work that is before us is to get government to act in a particular way, especially where there are clear provisions. So Section 69 of the Constitution, which speaks to the Cabinet being the principal instrument of policy, charged with the general direction and control of government, also speaks to Cabinet being collectively responsible, therefore, to the Parliament. And I think we will have to get into a different way of operating. We do have policies coming to the Parliament in the form of discussion paper. I think that's the green paper. And then the actual policy, which is a white paper. But as we go through, the reform process that we're in, it is truly my hope that we will have more discussions in the Parliament around policy issues, especially the issues on which legislation will be grounded. I thought I'd just make that comment on that matter. I see that a recurring question has arisen, and it's connected to the first point about policy and law, which I think requires some clarity for both parliamentarians and members of the public who may be listening. The way government is structured in ministries, departments, and agencies, subject matters are assigned, and depending on where a subject matter is assigned, the ministry will have responsibility for the laws related to those matters. And so when we say that if you raise a point which relates to another piece of legislation, we can't amend it in this bill that is before the House. It is my hope that you understand it is because of how government is structured. Now, the Ministry of Legal and Constitutional Affairs has an overarching responsibility across all of government, and we certainly will take note and carry the message to the relevant minister and ministry of all concerns raised in deliberations which may require an attention, a legislative attention in a matter under their portfolio. All right? The third thing is a concern about abuse, and it's also linked to the issue of accountability. It's going to be important as we think through and as we participate in the process that we make a distinction between matters that are provided for in law and matters where the real concern has to do with how the work is done. You may have an adequate provision in the law, but concerns arise as to how the duties are carried out, how the functions are exercised, how the powers are discharged. And for those matters, the problem would not require a legislative solution, but they would require other actions. So it's going to be important for us always to distinguish what kind of solution is required to address the problem. I think those are they from my comments. But the other matter has to do with the guidance that was sought and expected from the chambers. And I see that that guidance was circulated in a letter to the clerk, letter dated March 9, 2023, and I see that it was sent out to all committee members. I think that's the major matter arising for today's discussion, with the guidance that was sought on questions of constitutionality around the pre-charge provisions. Right, so unless there is any other matter that members of the committee would want to address, we would then go into the meat of the matter, which I know is this Section 5, the pre-charge bail regime. Any? I see a note. Okay. All right. So then shall we proceed to discussing, or is there another matter? Madam CPC? Yes.
Would you like me to just address the query made by Member Scott Motley before you get
Yes, I would appreciate. Thank you, Madam CPC.
Right. So the query was in relation to item 16, the reference there to the Law Reform Zones of Special Operations Act. It's listed in part 1 of the second schedule, which deals with the offenses in respect of which bail may only be granted by a judge. And that is provided for in clause 6.3, and that provision does not require the offense to be punishable with imprisonment in order for that provision to apply, because 6.3 states that in the case of a defendant who is charged with an offense listed in part 1 of the second schedule, the question of bail may be considered only by a judge. So the fact or the application or non-application of a sentence of imprisonment would not apply there.
Thank you, Madam CPC. I suspect the reason perhaps why the question is asked is that there is a scheme that applies to persons who are charged with offenses that are not punishable with imprisonment. And the expectation would be that if there is a particular offense not punishable with imprisonment, then it would fall under the regime in respect of those offenses.
But I thank Ms. Grant for responding, but it doesn't address one aspect of my question, which is what is so egregious about this offense? For my own edification, why it would be that the question of bail in these circumstances can only be considered by a judge.
I was coming to that.
Pardon me?
I was coming to that, but please go ahead.
Oh, because I would have thought, as a matter of fact, that this would be one of those where there would be no need to go before the judge because the investigations should be able to take place pretty quickly. I simply don't understand why it comes under that category. And I would like to hear what was the thinking behind including it.
Right. So
I did see, Ms. Grant, the provision in relation to 6.3. And in fact, my note against it is that it is an offense under the schedule nonetheless.
Senator, Member Scott Motley, I appreciate the concern that if the regime speaks to differentiated treatment for defendants suspected of or charged with offenses. No, let me start again. The regime differentiates treatment for persons charged with offenses not punishable with imprisonment. And in such a case, bail shall be granted unless any of the exceptions set out in the law arise. In respect of the offense relating to identity, I think it goes to the heart of who is to be before the court or other authority. So it doesn't matter how outraged we are by allegations that an offense has been committed. And if we prove everything in relation to how it was done, but the person who's before the court is not the person who did it, and there is not proof of it, it really doesn't matter. Our outrage is to naught. So when it comes to the disclosure of your identity within the zone, it is because of the special joint operations taking place and to ensure that persons who are not under suspicion, because you have people who look alike, you have people who have similar names, are dealt with in a particular way. So the issues of identity and providing for failing to disclose your identity in those special options is one that is treated a little differently and with exception.
And I understand that, that, Chair, but I also know what the culture of Jamaica is. And I know that persons might be called by different names. Not because, and somebody might give a name, not with the intention to mislead or deceive. All I'm coming back to is that the deprivation of somebody's liberty is one of the greatest things. Next to the right to life, as we put it, deprivation of liberty is fundamental. And I just want us to approach it with due care and consideration, and to think also about what obtains in Jamaica, what is our cultural norm.
What I have found helpful in thinking through this matter, Senator Scott Motley, is what is provided for constitutionally, and it's not just within Jamaica's constitutional remit, but accepted within the community of nations. So the right to liberty is fundamentally guaranteed and guaranteed at the highest level, but it is not absolutely guaranteed. And the question is, under what circumstances may you properly be deprived of your liberty? I've just found it helpful to think about it, because there are many issues, many issues. When we're dealing with the law, the question is, so the Constitution guarantees the right, not in an absolute way, and it sets out the circumstances in which you may lawfully, constitutionally be deprived of the liberty. When we are passing the ordinary law, are we honoring that standard? And if the legislation honors that standard, the next question is whether those who are implementing the law are doing so lawfully. So I have found it helpful to just think through it. Otherwise, the problems may be so big. So the Constitution does provide as an exception to the guarantee to the right of liberty that you can be, if you can be deprived if you're reasonably suspected of having committed an offense. And
as with the right
just
to
found
life,
it,
Millie, as with the right to life, you can be deprived if you're committed an offense.
no, you're not deprived of you're not deprived of your right to life if you have committed an offense, is if you have been convicted of an offense which carries the death penalty.
I thought that was accepted.
No, because it's a different situation because the stage of deprivation of the right is different. So the deprivation of the liberty comes at an early stage where you are arrested or detained on reasonable suspicion of having committed an offense. The deprivation of the right to life lawfully under the Constitution would come after you have been convicted of the offense which carries the penalty of death, and also after the sentencing hearing would have been done.
What I was enjoining and agree with you is that there are no absolute rights.
Ah, I see.
Right.
I see. Got you.
That was what I was enjoining.
Sorry. Got you. Right. So in this case, it is because the issue of identity is core when we're talking about offenses. And this one is treated a little differently. So, concerns, like I say, I've just found it helpful to think through the issues in a certain way. And thinking them through in this way doesn't mean that you solve all of the problems, the real problems, but for the legislation now is to understand that this guaranteed right is not absolutely guaranteed. The Constitution sets out the exception, and whether the law dealing with that exception is in accordance with what the Constitution says and what flows thereafter. So I think all who are watching should understand and appreciate that the right to liberty, the freedom that we all prize so much, is not an absolutely guaranteed right, critically important as it is. There are permissible limitations on that right that has been guaranteed, and at all stages we have to ensure that actions taken are taken within the permissible limitations.
It may be that the way that offense is cast in that law may need to be looked at. It's done, it presents it as a relatively minor offense. The imprisonment period is a maximum of 10 days. And so the period of imprisonment, the quantum of the fine, it's not conveying that level of that gravity. So I don't know.
I appreciate that point, Ms. Wilkins, and that is why I said I understood the concern because of the differentiated treatment that we have provided for where the person is suspected of or charged with an offense that is not punishable with imprisonment. Usually, the offenses that are regarded as not serious would be given a lesser sentence. And if the failure to disclose identity in those circumstances is regarded as so serious, why is the penalty what it is? All right. Thank you for raising that, Member Scott Motley. Can we then move on now to the guidance to be provided by the Attorney General's chambers on some of the constitutional questions raised? Before we go there, there's a little housekeeping matter. We are now at 12:43. We will need to take a lunch break perhaps we can decide on what that time should be or could be, so we get an indication. Member Campbell Rodriguez.
Madam Chair, given that we're here for an all-day meeting, I know we started a little bit late, but the time is still the time. If we could break before we get into the substantive, I don't know what the other members of the committee think, we could just break now and then we come back to the real meat of what we want to do today. That's my suggestion.
The suggestion is that we take the lunch break at this time before we get into the meat of the matter of hearing from the Attorney General's chambers. Those who are joining online, may I have your input?
Sorry, I support the recommendation. I would like to know, though, at the same time, what time we intend to resume, if you don't mind.
Right. Okay. Yes, Mr. Foreman?
Sorry, I was going to say that I didn't intend to take very long. I'm not going to read the entire document, just to summarize the essence of what it says.
All right. Let us at least go up to 1 o'clock and then we reassess at that stage. That's okay? All right. The proposal would be for about a 30 to 45 minutes break when we get there. Member Scott Motley.
Thank you.
Yes. All right. So we will utilize the next 15 minutes and see where we get to at 1 p.m. Mr. Foreman, I invite you to provide the guidance to the committee on the matters raised and those that are set out in your letter of March 9, 2023 to the clerk, to the Houses of Parliament.
Thank you, Chair. The letter is 21 pages, which I don't, as I said, intend to read. So I'll just summarize the essential points.
Please recall that the concerns around the constitutionality of the provision, the regime, is of particular concern to members. But the good thing is that you have provided the thoughts of the chambers in writing for all members to see. But let us hear your summary.
So at the last meeting, questions arose regarding the submissions made by various groups regarding whether there was any constitutional basis for any form of regime that could permit detention of an individual prior to charge. And I
ask that you speak a little more directly in the mic.
I think it's the mic, you're right.
Yeah.
The detention of persons prior to charge and whether any conditions akin to bail could be imposed on such a person. I considered those submissions in the context of Section 14 of the Constitution of the Charter and against the background of the interpretations that I was able to find that have been placed on those provisions by the courts of Jamaica, and as well the interpretation placed on Article 5 of the European Convention on Human Rights. The broad conclusion is that there is at least an arguable basis to conclude that Section 14(1)(fi) of the Constitution permits arrest or detention of a person on reasonable suspicion of having committed an offense in circumstances where there's insufficient evidence to their charge against that person, and that anyone who is arrested or detained pursuant to that provision are entitled to be released either unconditionally or on reasonable conditions to secure their attendance at a later stage of the proceedings against them. And those particular provisions in the pre-charter regime, as I'll reference later, have been accepted as contemplating the imposition of bail. So just to summarize the various points, Clause 5 of the bill as it is now structured provides that a person who is arrested or detained on reasonable grounds that an offense listed in parts 1 or 2 of the schedule to the bill has been committed may be arrested or detained for that offense. And then it provides a regime for the question of bail to be considered in the first instance by a justice of the peace or a constable at or above the rank of superintendent. There have been some discussions about who can make those decisions, and thereafter by a parish court judge, and the parish court judge is then in a position to determine whether the person should be released or held in detention for a period that the parish court judge specifies. And if someone continues to be on bail in this context for a period of 6 months without charge, the person has to be, the conditions have to be removed completely unless a parish court judge authorizes the continued imposition of those conditions. So the submissions that have been made to the committee in large part argue that the Constitution, and in particular the Charter, does not use language that, to their minds, speaks to pre-charge bail. The Bar Association, for example, focused its argument in this regard on the fact that Section 14, subsection 4, speaks to an entitlement to bail to someone who is awaiting trial. And the implication, they say, is that if the Constitution speaks specifically to bail in the context of trial assumes that a charge has been already laid. It, by implication, excludes bail in a context outside of a trial and a charge. Those arguments in different language are mirrored in the submissions of the Norman Manley Law School, which said that in their view, the Constitution excluded contemplation of, and therefore specific protection for a pre-charged defendant, and that failure would support an argument that there is no power to do so. Similarly, the IJCHR in its oral submissions indicated along the same lines, though I did note that in the written submissions, they argued that the decision to restrict freedom in the context of bail to a particular person such as this should only be done by a judge. So the written submissions suggest, well, you can do it, but only if a judge is doing it. But as I said in the oral submissions, they expressed opposition to it. And Jamaicans for Justice, their difficulty with the provisions in their written submissions largely revolved around concerns about possibility for abuse of that power. But in their oral submissions, they also emphasized that they don't think it is a regime that is consistent with the Constitution. And the Cornwall Bar Association, who did not provide oral submissions but did provide written submissions, also expressed their views along those lines, but they didn't provide reasons for those conclusions. So against that background, one looks to see if there's anything in the Charter that one could view as allowing for a regime such as is contemplated by Clause 5 of the bill. And the only relevant provision that one can identify in this regard is Section 14, and in particular, Section 14. And the basic format of Section 14 is that its overall objective is to prevent the arbitrary detention of persons, as well as to ensure that persons who are lawfully arrested or detained are treated in a particular way. Okay, and so, for example, well, let's just focus on the one. So the basic structure of it is that it sets out circumstances in which a person may be deprived of their liberty. For example, they've been convicted by a court, you can be deprived of your liberty in that context, and then sets out the legal entitlements of that person. So somebody who is arrested has the right to be informed of the reason for their arrest in language that they understand. The relevant circumstance of detention in this context is 14(1)(fi), which says that a law can be made to provide for the arrest or detention of a person for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense. So the question that arises, what is the meaning of those words? And for that, we will seek guidance of the courts. The clear words themselves could lead to one conclusion one way or the other. And the relevant legal entitlement to such a person is found in subparagraph 3, which says that any person who is arrested or detained shall be entitled to be tried within a reasonable time and shall be brought forthwith or as soon as reasonable practicable before an officer authorized by law or a court and released either unconditionally or upon reasonable conditions to secure attendance at the trial or at any other stage of the proceedings. And that if the person is not released, that person shall be brought promptly before a court, which may thereupon release him as provided in that paragraph. So the duty is to bring the person before an individual who can then consider whether the person should be released or released, either released or released unconditionally. And if there's no release in that regard, you get to the stage of contemplation by a court. So as I've said, the question is whether 14(1)(fi), those words can be read to mean that somebody who has not been charged, but they have been reasonably suspected of having committed an offense, could be detained. I wasn't able to find any clear guidance on the point from courts in Jamaica, and by in Jamaica include the Judicial Committee of the Privy Council in that. The closest case I've found so far in which those provisions have been contemplated is the case of Mervyn Cameron against the Attorney General, the first of the Mervyn Cameron against the Attorney General cases. There's another one that's pending. Oh, okay, good. It was necessary to drop the voice for that one, don't worry. But this is a 2018 decision in which a decision of the Supreme Court considered by the full court, so that's to say three Supreme Court judges. And the issue there was the question of the entitlement to a trial within a reasonable time. So the court had to consider sections 14 and 16 of the Charter. Section 14 deals with personal liberty. Section 16 deals with various due process rights of an individual, so that those rights that people are entitled to when they are before courts or before tribunals in the civil context. So the court had to consider those two provisions because both sections 14.3 and 16.1 of the Constitution speak to a fair hearing within a reasonable time by an independent and impartial court established by law. That's in relation to section 16.1 and 14.3, a right to be tried within a reasonable time. So you have two provisions in the Constitution that, on the face of it, cover the same terrain.
Just seeking clarification, I thought you said you had not found any matter in the Jamaican court which dealt with it.
Sorry, directly on the question of pre-charge.
Oh, well, we wouldn't. Yeah. Okay, go on.
Right, so I'm trying to be as specific as possible.
Is a matter, the Mervyn Cameron is a matter considered by the full court of Jamaica.
Correct, yes.
Right. Just clarifying that, because it may have come across differently.
Oh, understood. Right, so in this case, there's some statements by the judges regarding the relationship between sections 14 and section 16. Justice Sykes, as he then was, for example, in articulating the differences between those two sections, said the two provisions are linked in this way. Both provisions may be engaged simultaneously, in that a person's arrest and charge may occur concurrently. If that is the case, then the right to be tried within a reasonable time and the right to a fair hearing within a reasonable time by an independent and impartial court established by law would be activated simultaneously and immediately. On the other hand, a person may be arrested or detained but not charged, and therefore only section 14.3 is engaged. Section 16.1 is only engaged when the person is charged with a criminal offense. In the period after detention or arrest and before charge, section 14 details what is expected to be done in respect of the person arrested or charged. Now, the text of the judgment uses charge there, but I think that's an error. Because when you read the sentence, the judge is clearly contemplating the period of time before charge is actually imposed. As I've said, while not directly addressing the question of pre-charge detention and the entitlements of the person in that context, when the judge here reads a provision and is articulating the meaning of the provision, there's an acknowledgement that arrest or detention can occur before charge, and that where that happens, Section 15 is fully activated. That is to say, the various entitlements of the individual upon arrest or detention is engaged. And if one extrapolates from that to the broader principle, one would come to the conclusion that provided that there is reasonable suspicion of a person having committed an offense, even if that person is not charged, they are entitled to the various provisions in Section 14. I also quoted from Justice Fraser, large, again, as he then was, has also had a promotion since this judgment. The main reason for that is to highlight the fact that he, as I read him, considered Section 14.3 as a bail-related provision. And as I, let me go on. So that was the extent of case law that I could find in Jamaica on those specific provisions. So the next step was to consider if there is any guidance that could be found in other places. And the main source for that guidance in this context, I would submit, is the European Convention on Human Rights. That is so for two reasons. One is that from a historical perspective, the human rights provisions that we've always had in Jamaica were modeled on the European Convention. So that's a pre-charter provision. And some of those provisions continue in the Charter. And in the Attorney General against the Jamaica Bar Association, the recent decision concerning the poker regime, the Privy Council acknowledged that the Charter is loosely based on the European Convention on Human Rights. I'd use a bit stronger language than that, but that's fine. Article 5 of the European Convention says that, and I'll just read it just to bring about the textual similarity. Everyone has the right to liberty and security of the person. No one shall be deprived of his liberty, save in the following cases and in accordance with a procedure prescribed by law, listing out the provisions. And in C, it says, the lawful arrest or detention of a person effected for the purpose of bringing him before the competent legal authority on a reasonable suspicion of having committed an offense, or when it is reasonably considered necessary to prevent his committing an offense or fleeing after having done so. And just reading that, you will pick up the similarity between that provision and the provisions in the Charter. And then Article 5 goes on to say that everyone arrested or detained in accordance to the provisions of paragraph 1C, in the provision I just read, shall be brought promptly before a judge or other officer authorized by law to exercise judicial power and shall be entitled to trial within a reasonable time or to release pending trial. Release may be conditioned by guarantees to appear for trial. Again, those words very similar to what we find in the Charter in relation to Section 14.3. So the letter then goes on to indicate that in addition to the textual similarity, there's a strong historical resonance between the personal liberty provisions in the Charter and the personal liberty provisions in the European Convention, and that when one looks at the legislative history of Section 14, what I discern from that is that the Joint Select Committee that considered the Charter of Rights wanted the personal liberty provisions to reflect the text of the European Convention, the similar provision in the European Convention, and that they also introduced that Section 4 that specifically referred to bail, which was not in the pre-Charter provision. So the next step is to consider the interpretation that the European Court of Human Rights has placed on Article 5, and I list a series of cases where the court has essentially had a very consistent view on the content of that provision. So I'll just refer to the main one and move on from there. So there's a case called Brogan against the United Kingdom, which is a seminal case interpreting Article 5.1c of the European Convention on Human Rights in the context of detention. Brogan was arrested on suspicion of having committed certain offenses. He was detained for a certain period of time. After his arrest, he was questioned about his involvement in an attack on a police patrol that resulted in the death of an officer and injury to others, as well as his alleged membership in a proscribed organization. There were other litigants in the case, but Brogan was the named litigant, and all the litigants were detained because there were, and I quote, reasonable grounds for suspecting them to have been involved in the commission, preparation, or instigation of acts connected with the affairs of Northern Ireland. So none of them were charged with the offenses for which they were suspected of having committed, and were released after being detained for various periods of time. Now, the contention made in the case by Brogan and others was that the arrest and detention breached Article 5.1c because the purpose of the arrest was not to bring them before the competent legal authority. The European Court did not agree with that. The court assessed the record and was satisfied that the arrest and detention was based on a reasonable suspicion of having committed an offense within the meaning of 5.1c, the equivalent of 14.1 of the Charter. And the European Court further concluded that the purpose for which the arrest and detention was effected was also consistent with that article. So the court said, and I now quote, the fact that the applicants were neither charged nor brought before a court does not necessarily mean that the purpose of their detention was not in accordance with Article 5. The existence of such a purpose must be considered independently of its achievement, and subparagraph C of Article 5 does not presuppose that the police should have obtained sufficient evidence to bring charges, either at the point of arrest or while the applicants were in custody. Such evidence may have been unattainable, or in view of the nature of the suspected offenses, impossible to produce in court without endangering the lives of others. There is no reason to believe that the police investigation in the case was not in good faith, or that the detention of the applicants was not intended to further that investigation by way of confirming or dispelling the concrete suspicions, which, as the court has found, grounded their arrest. So the court is saying on the facts of this case, the police had reasonable suspicion, and we accept that they were actively pursuing this investigation. The court goes on, had it been possible, the police would, it can be assumed, have their charges, and the applicants would have been brought before the competent legal authority. their arrest and detention must therefore be taken to have been effected for the purpose specified in paragraph 1C. And the court then considered whether the police had in fact complied with the requirement to bring the person before a competent legal authority for the question of bail, essentially to be considered. And on that separate question, the court wasn't satisfied that the police had brought them before a judicial officer in a prompt way. So the court accepted that the detention was lawful and acknowledged that what should have happened was that they should have been brought before a judge for that judge to then decide what to do. The rest of the letter identifies just records the consistency with which the European Court has applied the principle just referenced, and also the way that the European Court has also treated the provision regarding bail. So there's a case called Wemhoff against Germany. The allegations there involve matters of complex fraud and things of that nature. The applicant had been detained for a period of time before the charges were actually brought. And during that period of time, he had applied to the courts for bail. The courts had refused it, expressing concerns about that he might abscond and things of that nature. He challenged those decisions to not grant him bail, and the European Court thought that the German courts acted properly in denying him bail, having regard to the factual record before them. So the European Court of Human Rights jurisprudence on the language that is very similar to the language in the Charter reveals that arrest and detention on reasonable suspicion of having committed an offence is consistent with the European Convention, even if the evidence grounding the arrest or detention is not yet at the level that can substantiate charge, so long as there is reasonable suspicion. Detention in those circumstances requires that the individual be either released or brought promptly before a judge or officer authorized by law to exercise judicial power. That's consistent with the language of the ECHR. And that the judge or officer authorized by law to express that power can release the person or conditions, or authorize the continued detention if there is a justified basis in the public interest to do so. So that if the reasoning of the European Court of Human Rights is made to apply to the Charter, one would expect the same conclusions in relation to the meaning of sections 14.1fi and sections 14.3 to apply. The last major point that the letter considered was international human rights instruments, really just one instrument, the International Covenant on Civil and Political Rights. Article 9 of the ICCPR deals with the personal liberty of individuals. It's differently structured to both the Charter and the European Convention. The difference is in two parts. The first is that Article 9 allows for arrest or detention if there is a law in place that authorizes the arrest or detention, but it does not specify the conditions in which that can be done. Right? So both the European Convention and the Charter specifically enumerate specific grounds on which the law can provide for detention. The ICCPR does not do that. And secondly, the ICCPR speaks to the grant of bail to a person who has been arrested or detained, specifically frames that entitlement in the context of a person who is arrested or detained on a criminal charge. And as I've said, neither the European Convention nor the Jamaican Charter frames the entitlement in that way. Now, when one looks at the interpretation that the UN Human Rights Committee, which is the main body charged with providing guidance and interpretation on the ICC PR, its comments on the meaning of these provisions indicates that the requirement that anyone arrested or detained on a criminal charge shall be brought promptly before a judge or other officer authorized by law to exercise judicial power and to be released either subject to guarantees to appear for trial or at any other stage of the proceedings. The Human Rights Committee acknowledges that the requirement applies even before formal charges have been arrested, so long as the person is arrested or detained on suspicion of criminal activity. The right is intended to bring the detention of a person in a criminal investigation or prosecution under judicial control. So, in other words, notwithstanding the fact that the right specifically says post-charge the person is entitled to bail, the ICCPR has said that even before the person has been charged, so long as they are arrested or detained, they should be brought before an officer to consider whether release should be granted or release on conditions. And so those are the two main external sources, as it were, that I've found, which provided some degree of guidance on how the charter might be interpreted. And I suppose I'm open to any questions.
Thank you so much, Mr. Foreman. I think we're at that point where we would take the lunch break and allow members of the committee to ruminate. They would have already been provided with the written details. So I would say that, yes?
May I just ask that we on page 7 of 21, where the quote is from Chief Justice Sykes, it actually ended prematurely, and I wondered if we could be provided with the full sentence, Mr. Foreman. It stops at, it has a note that the paragraph was not completed. If you look at page 7 of 21, the first paragraph, you have a note at 13. Are you seeing it, Mr. Cameron?
Yes, I see it. I'm trying to find it.
I wonder could we have that complete sentence?
I think it's complete, but I'll check.
Thank you.
The sentence that ends with sick?
It says it says in the period after detention or arrest and before charge, section 14 details what is expected to be done in respect of the person arrested or charged. But it has this sick, so.
Sick just means there's an error. Typo error.
I thought it meant that it was incomplete, that he has deleted a section.
Oh, right.
I thought that's what that meant, not that there was an error.
No, the sick is usually used. Right. But
could you just ask him to check to make sure that it's complete? Because the thought seems incomplete.
All right. So we can have that checked during the lunch break. We will therefore take the break now and resume at 5 minutes to 2 for a 2 p.m. restart. Committee is hereby adjourned for lunch.
It's Thursday, March 23. In the headlines, local news, the Jamaica Police Federation signs compensation deal. In business news, gas prices down. In the region, the Bahamas government backs Mexico's $10 billion lawsuit holding U.S. gun makers liable for gun trafficking. Internationally, after arrest warrant for Putin, Russia opens its own case against the ICC. In sports news, no rigid sanitization regime for the full schedule champs set to begin in the last week of March. This is the news on PBC Jamaica. I am Maya Chung. Minister with responsibility for information Robert Morgan says the government is protecting the rights of all Jamaicans in the wake of mixed marks from the American State Department in its performance in that area in 2022. The remarks are in response to a report from the U.S. State Department. Simone Absalom Gale reports.
In its report released on Monday, the U.S. State Department gave the Jamaican government low marks for its performance in areas such as fatal shootings by members of the security forces, among other things. However, responding to the report, Minister Morgan told the press that the critique has been noted and the government will have to look at those areas as it moves to improve the lives of all Jamaicans. He's quoted saying, "The government of Jamaica continues to focus on the protection of human rights for all citizens. We are developing a country and we do have challenges, but the government has continued to work to address these challenges to ensure we protect the rights of every single citizen." End quote. Simone Absalom Gale reporting for the news on PBCJ.
The Jamaica Police Federation has joined the list of public sector bodies who have signed on to the public sector compensation restructuring. Finance Minister Dr. Nigel Clark says the agreement was signed on Tuesday night. He confirmed in a tweet saying, quote, "This signing of this MOU now paves the way for $10.2 billion to be paid out to our rank-and-file policemen and policewomen, representing retroactive amounts given the April 1, 2022 implementation date of this reform," end quote. Dr. Clark had told the members of the lower house that the signing of the agreement by the Federation would bring to 95% the number of public sector workers who have agreed to the new compensation structure.
Madam Speaker, we expect that certainly for the groups who have signed, the retroactive payments will be paid out this month. It may not come on the 25th clearly because a lot of the agreements were just signed. Some of them have been signed today. Today's the 21st. But we will endeavor that the funds will leave the consolidated fund by the end of the month.
The Police Officers Association, POA, which represents gazetted officers of the JCF from the rank of Assistant Superintendent to Commissioner, is among groups yet to accept the new wage offer under the review. The activities to define the observation of National Math Week were announced on Wednesday, March 22 by National Math Coordinator with the Ministry of Education and Youth, Tamika Benjamin, at a JIS think tank session. Ms. Benjamin outlined some of the events scheduled.
The Ministry of Education and Youth has designated the week of March 26 to March 31, 2023, National Mathematics Week. One of the objectives of the National Mathematics Program is to improve the attitudes and the culture towards mathematics teaching and learning in Jamaica. We recognize that a number of our children and our teachers and parents have a negative attitude to the subject and are sometimes unable to see the relevance of the subject to their everyday life and experience. And we believe that that is a significant part of the barrier we need to break down to improve student performance in mathematics across all levels of the education system. We started celebrating National Mathematics Week in 2013, and managed to maintain activities for at least 2 years through the period of the pandemic. I believe the activities were disrupted in 2020 at the initial onset of the pandemic, but we managed to facilitate activities in 2021 and in 2022, mainly virtually. So since we have gone back fully to face-to-face in terms of teaching and learning, this year will be the first time since 2020 when we will resume our face-to-face activities for National Mathematics Week.
Activities should kick off on Sunday.
We begin on Sunday the 26th at 10 a.m. with a church service, which will be held at the Clifton New Testament Church of God on Mannings Hill Road. And all persons are welcome to join us as we commit the week of activities to the Lord, as well as continue to pray, because this is something we believe requires prayer for change and growth, the growth that we want to see locally. Then on Monday the 27th of March, we gather at the University of the West Indies in the Assembly Hall for the launch of the week of activities, and embedded in that program will be the award ceremony for the 2023 Mathematics Teacher of the Year competition, which is a joint venture between the Ministry of Education and Youth and the Jamaica National Group.
According to Ms. Benjamin, there will be 7 regional activities in which Jamaica will be participating. The activities were designed with all stakeholders in the development of a math-positive population in mind.
One of the things we are again trying to do, we started it in 2021, is to use a week of activities to engage a wide cross-section of stakeholders. So we know most of our activities will target our teachers and students, but we also recognize the importance of parents to this conversation and to our drive to change the attitudes to the subject. So we're having that session that will be facilitated on Wednesday, the 29th, virtually.
She raised the idea of STEM innovation during the session.
On Friday, we will launch a STEM innovation village. Again, last year, we started to help students see the very strong link between mathematics and STEM, particularly when we recognize that there are a number of STEM jobs within the local market that are currently underserved. And so we wanted to use it as an opportunity to show students some direct, lucrative opportunities that are available for them should they want to pursue those careers.
And it's now time for the business report with Danita Rodney.
Motorists should see a decrease at the pumps in the price of gasoline effective Thursday, March 23, according to the latest ex-refinery cost from Petrojam. With both grades of gasoline down by $3.06, 87 octane will sell for $164.76 per liter, while 90 octane gasoline will sell for $169.24 per liter. Down $4.50, automotive diesel fuel will sell for $191.62 per liter, ultra-low sulfur diesel will sell for $202.47, and kerosene will sell for $202.67 per liter. Continuing with the $4.50 decrease, propane liquid petroleum will sell for $64.45 per liter, and butane liquid petroleum will sell for $70.92 per liter. Remember, marketing companies and retailers will add their respective markup to these prices. Tax Administration Jamaica THA is reminding employers that the due date for filing the employer's annual return SO2 is Friday, March 31, 2023. Taxpayers are reminded that the return must be filed online using the tax portal at www.jamaicatax.gov.jm and can only be done once employers and/or their agents are registered to do so. The tax authority is also reminding the public that it will open select tax offices this Saturday, March 25, 2023, which represents the last of the month-end Saturday operations for the financial year 2022-2023. The following tax offices will operate this Saturday between the hours of 10 a.m. to 2 p.m. St. Andrew, Constant Spring, Montego Bay, FCJ Building at 11 to 12 Almond Way, Montego Bay, Freeport, Mandeville, Savannah Lamar, and St. Anne's Bay. The Saturday service enhancement continues to provide taxpayers with a convenient option of doing business on these weekends, as well as to alleviate the usual high walk-in traffic at tax offices during the busy month and weekend period. Now for your market updates. In foreign exchange trading for Wednesday, March 22, the US dollar sold for an average of $151.71. The Canadian dollar ended trading at $112.03. The pound sterling traded for $185.83, and the euro sold for an average of $166.10. In JSE trading, the JSE index advanced by 1,812 points. The junior market index declined by 46 points. The combined market index advanced by 1,251 points. And the All Jamaican Composite Index advanced by 2,900 points. Overall market activity resulted from trading in 124 stocks, of which 34 advanced, 47 declined, and 43 traded firm. Stocks advanced for AMG Packaging and Paper Company Limited, Barita Investments Limited, and Caribbean Assurance Brokers Limited. Stocks declined for 138 Student Living Jamaica Limited, Access Financial Services Limited, and Berger Paints Jamaica Limited. Trading firm were Blue Power Group Limited, Caribbean Cream Limited, and Elite Diagnostic Limited. The overall volume leaders were Sagicor Select Funds Limited Financial with over 4 million units, Wigson Wind Farm Limited Ordinary Shares with over 3 million units, and Sagicor Select Funds Limited Manufacturing and Distribution with over 2 million units. In regional stocks, in Trinidad and Tobago, Calypso Macro Index Fund posted a volume of 530 shares. On the Barbados Stock Exchange, First Caribbean International Bank was the sole security trading 300 shares. In regional business, with greater access to the internet and technology in Guyana following the liberalization of the full telecommunications sector in 2020, Guyanese businessman Andre Robinson is hoping to help state agencies and businesses to bridge the digital divide.
Andre Robinson left Guyana as a teen and lived for many years in Africa and the United States. With over 20 years' experience in the technology field and currently serving as an advisor to government agencies in New York and New Jersey on IT solutions, he's hoping to use some of his skill set, experience, and knowledge to bridge the digital divide in Guyana. In so doing, he has started his own business, Modernize IT Solutions, and is confronting the task of transforming Guyana's technological landscape to international standards. Launched in December 2022, the business currently offers an intelligent Wi-Fi system, providing sophisticated levels of security for corporate data and people connected to the Wi-Fi of companies and agencies.
So currently, the services we offer, we have an intelligent Wi-Fi system. So basically, with this system, any business that typically shares their Wi-Fi with their visitors, with their guests, right? So for example, like a restaurant, they would share their Wi-Fi, with the patrons that are coming in to, dine, right? This Wi-Fi system, it can be used for several purposes, right? But the main purpose would be security. A lot of times businesses, when they share their Wi-Fi, they got to give out the Wi-Fi password. And that password, if someone knows the login portal or the login to get to the back end of the Wi-Fi system, they can get in there and they can do some malicious activities, right?
The intelligent Wi-Fi system, Robinson says, can also be used by local businesses for marketing, advertising, and collecting feedback.
You can use your Wi-Fi to advertise to those people who are connecting to your Wi-Fi. So you make it a process whereby they have to see that ad before they can use the Wi-Fi. If they don't, if they say, no, I don't want to look at this ad, then they can't use it. So you make it mandatory, right? So you can use it for advertising. You can also use it for marketing.
Robinson is also leveraging artificial intelligence and is in the process of designing robots to help with the overall improvement to service delivery.
In international business, the Federal Reserve raised interest rates by 1/4 percentage point, but indicated it was on the verge of pausing further increases in borrowing costs after the recent collapse of 2 U.S. banks.
Amid recent turmoil in financial markets spurred by the collapse of 2 U.S. banks, Fed Chair Jerome Powell Wednesday announced an interest rate hike of 1/4 percentage point and indicated the Fed was on the verge of pausing further increases, as Powell warned that stress in the banking industry could trigger a broad credit crunch with significant implications for the U.S. economy.
We believe, however, that events in the banking system over the past 2 weeks are likely to result in tighter credit conditions for households and businesses, which would in turn affect economic outcomes. It is too soon to determine the extent of these effects, and therefore too soon to tell how monetary policy should respond. As a result, we no longer state that we anticipate that ongoing rate increases will be appropriate to quell inflation. Instead, we now anticipate that some additional policy firming may be appropriate.
The Fed's relentless rate hikes to rein in inflation are among factors blamed for the biggest banking sector meltdown since the 2008 financial crisis. Policymakers have stressed the turmoil is different from the crisis 15 years ago, saying banks are better capitalized and funds more easily available. Powell insisted the system was sound after the spate of actions that the central bank and other regulators have taken in the last 2 weeks.
These actions demonstrate that all depositors' savings in the banking system are safe. We will continue to closely monitor conditions in the banking system and are prepared to use all of our tools, as needed, to keep it safe and sound.
But while deposits might be safe, the recent banking dysfunction could hurt consumers in other ways. As banks pull back, loans might be harder to come by. Christian Ledoux is a director at Cap Trust.
The banking situation is actually disinflationary, as banks are going to be responding to this by loaning less and being a little bit more conservative.
That could help the Fed back off its inflation fight. This is quite a shift from a few weeks ago when a series of stronger than expected economic reports had raised concerns the Fed would continue lifting rates longer than anticipated and to a higher level.
In market data for oil prices dipped, having hit their lowest since late 2021 earlier this week. Brent crude futures were down 54 cents to $76.15 a barrel, while West Texas Intermediate crude dropped 62 cents to $70.28. And that was the business report on PBCJ. I'm Denita Rodney.
In regional news, the Bahamas is backing Mexico's $10 billion lawsuit to hold American gun makers liable for facilitating the trafficking of American-made guns. Marlena Leonard has the story.
In our view, is that the right to bear arms cannot mean a right to traffic in arms.
Prime Minister Philip Davis announcing the Bahamas, Antigua and Barbuda, St. Vincent and the Grenadines, and Trinidad and Tobago are teaming up with the Latin American and Caribbean Network for Human Security to join Mexico's case to hold American gun manufacturers responsible for their role in gun trafficking. Mexico's first case against the U.S. gun manufacturers was dismissed in September of last year. When asked if Davis has any fears that this appeal may also be dismissed, he says,
I acknowledge that the case will not be easily won. You would have heard me say that in my opening remarks. All right, but we think that by joining our voices together, it will attract the attention of the lawmakers in the United States to demonstrate how serious we are about this concern. I think the case was dismissed on legal grounds, and whether it'll be successful or not will rest on the interpretation by the Court of Appeal of those legal grounds.
In front of a table of over 100 guns, Commissioner of Police Clayton Fernander tells us of their origin.
Almost 95% of our serious crime is as a result of firearms. The year 2022, we were able to take 400 weapons off our streets. 90% of the weapons traced from the U.S., and this is the highest in the region.
Newly elected president of the Guyana Olympic Association, Godfrey Monroe, said the new executive body is keen on forging partnerships with the government through the Ministry of Culture, Youth and Sport and the National Sports Commission to drive the process of development.
Minister, we'd like to thank you for taking the invitation on short notice to meet with us. I think it's truly a dawn of a new era. The roadmap that you've outlined in terms of the alignment and objectives of the government and Sports Commission is in alignment with the Olympic Committee. I believe all the international federations also. There's similar synergies and partnerships that rely on our collective engagement. I believe this committee is quite committed to the task of propelling sports in a new direction, and we're happy for this meeting and for our future collaborations and engagement. So, thank you.
In St. Kitts and Nevis, Prime Minister Dr. Terence Drew joined colleagues in Grenada for the 2023 RSS Council of Ministers meeting, where several matters of regional security were discussed. Glenn Bart reports.
Prime Minister Drew was accompanied by the Permanent Secretary in the Ministry of National Security, Ms. Cecile Hull, the recently appointed Commissioner of Police, Mr. James Sutton, and the Commander of the St. Kitts and Nevis Defence Force, Lieutenant Colonel Anthony Comrie. Referring to the 22nd March meeting, Dr. Drew posted, quote, "The one-day meeting provided a platform for regional leaders to exchange ideas and discuss best practices for enhancing regional security," end quote. The meeting heard opening remarks from current chairman of the RSS Council of Ministers, Prime Minister Dickon Mitchell, and the RSS Executive Director, Commodore Errington Sherland.
The RSS continues to build out its capacity and that of member states in responding to transnational crime beyond a traditional approach of incarceration and fines. The vision is to bankrupt the criminals by removing their heartbeat, the money, the profit, or the assets involved in engineering or resulting from these criminal activities. To this end, the RSS, through its Asset Recovery Unit, the ARU, in collaboration with the Caribbean Financial Action Task Force, is working to implement the FATF 40 recommendations and 11 immediate outcomes across member states. Further, the ARU cooperates with other agencies such as CARICOM Impacts to develop capacity in asset recovery and financial investigations in the wider Caribbean region. Our citizenry can rest assured that the response mechanisms of the RSS, along with its international diplomatic relations and partnerships, will function effectively to counter current and emerging threats to our societies.
At the RSS, we look forward to assisting our member states with diagnosing crime and security problems through the Regional Crime Observatory. We will continue to implement and assist with anti-corruption programs, and we will continue to assist and enhance the border security framework through robust assessments and adjustments to the coordinated response model. As we embark on our discussions today on the best approaches to tackling the common crime and security issues which compound us, we must equally assess the likely environment and the manifestation of the threats and risks to come in the medium to long term.
Also present were high-ranking officials representing the U.S. Embassy to the OECS in Barbados and a representative of the European Union. Glenn Bart reporting for SKN Newsline.
In news on the international scene, Russia has opened its own criminal investigation into the International Criminal Court's ICC prosecutor and judges, which issued an arrest warrant for Russian President Vladimir Putin recently. Russia's investigative committee says the ICC has knowingly accused an innocent person of a crime in a show of defiance against the court. The Russian probe comes after the court issued an arrest warrant for President Vladimir Putin for war crimes over the alleged deportation of children from Ukraine to Russia. Al Jazeera's Jonah Hull reports from London, the United Kingdom.
40 countries, fewer than a third of all signatories to the International Criminal Court, gathered in London, affirming their support for the court's work in Ukraine. The journey towards international justice will be long, its scope vast, and these mainly Western members of the court have pledged money and resources to the cause.
We share the belief that President Putin and the wider leadership must be held to account, and it's absolutely vital that we unite behind the ICC and that we support the Office of the Prosecutor with whatever it needs.
Appealing for support, the ICC's chief prosecutor said the very concept of international justice was at stake.
If we don't, at this moment in world affairs, cling to the law, if we don't look at ourselves and decide how we can do better, not just in Ukraine, but as nations, as member states of the United Nations, we will not only miss an opportunity, but we may not have further opportunities.
High on everyone's agenda was the first major step on that journey. Arrest warrants issued last week for Russian President Vladimir Putin and his Children's Rights Commissioner, charged with the illegal deportation of Ukrainian children. Russia's response a day after President Putin toured the Ukrainian city of Mariupol, now under Russian occupation, was to issue criminal charges against the ICC itself for ignoring Putin's immunity as head of state under international law. So the chief prosecutor of the ICC, Karim Khan, has urged countries here to find the stamina to deliver international justice. But the real test of that stamina will not be in pledges made at conferences like these, but in countries signed up to the ICC recognizing their obligation to deliver on its orders in the name of international justice. Like South Africa, a signatory to the ICC, which failed to arrest Sudan's Omar Hassan al-Bashir on an ICC warrant when he visited the country in 2015. President Putin is due there for a summit in August, and the South African presidency says it is aware of its legal obligations. Mr. Putin may have to rethink his plans, now a wanted man in the International Criminal Court's quest for justice. Jonah Hull, Al Jazeera, London.
In sports news, an air of excitement is now permeating the nation as students from across the country, the region, and wider international space prepare for the Issa Grace Kennedy's Boys and Girls Athletics Championships champs. In a discussion on the PBCJ program, PBCJ Presents, President of the Inter-Secondary School Sports Association, Issa Keith Wellington, indicates that all stakeholders in the legendary champs are welcoming back a full schedule event which was disrupted in 2019 by the COVID-19 pandemic.
Well, the last time we had full champs was 2019, but Issa has been leading in terms of trying to keep our students involved in various activities. So we did have champs in 2021 and 2022, but it was a very reduced version, very different from what we would have become accustomed to.
Champs Light.
Right, the Champs Light, right, Champs Light.
Mr. Wellington described the difference between the event as last held in 2019 to the full return of 2023.
Well, first of all, the most significant difference between what we are able to do this year and what we had to do after COVID is that we now are able to have more students participating because we are no longer, well, while we accept that COVID is not totally gone and there are still precautions that we need to take, there are a lot less restrictions on us. So in terms of the space that we occupy, we are able to have more persons in, so more students are able to participate. The schedule itself, we do not have that rigid scheduling of sanitizing
And you can watch that full interview this Friday on PBCJ Presents at 5 p.m. and a repeat on Monday, March 27 at 10 p.m. That's the news on PBCJ. I am Maya Chung. You can follow us on our social media platforms at PBCJamaica. Thanks for watching.
As an inner city youth, I'm a duty to know the laws and my rights. These laws affect all our self-interest and safety.
The law says throwing garbage in public places or on other premises without consent will lead to prosecution. I see it online. I know my laws and my rights. Do you? Know your laws. Know your rights. Respect you.
Bruises are much worse. You have to report him. Yeah, but if I go to the police station, they're just going to see it as another man and woman fighting.
Victims of domestic abuse can get help through the Domestic Violence Intervention Centers. Let me show you how to find one of these centers. Open the browser on your smartphone and type in jcf.gov.jm. When the page loads, scroll down to Resources and click on Domestic Violence Intervention Centers. This will give you a full listing of all the centers with their contact information. Or just walk into any police station and ask them to direct you to the nearest domestic violence intervention center where you can speak to a police officer.
A message from the European Union United Nations Spotlight Initiative in partnership with the Government of Jamaica.
Unsure of when you should apply for your NHT contributions refund? This is your reminder. The National Housing Trust, NHT, is now accepting refund applications for contributions made in 2015. Here is what you need to know. Eligible contributors must apply online. Customers may apply for their refund via NHT's website at nht.gov.jm or through its mobile app, NHT Mobile. The NHT has extended the cash refund granted to eligible public sector workers for 2023. For more information, you may visit their website, nht.gov.jm, send an email to wecare@nht.gov.jm or call 876-929-6500 or 888-225-5648. The National Housing Trust, the key to your home.
Jamaica, we are now facing severe drought conditions. Did you know that 12 of 13 parishes received below normal rainfall? 11 parishes experienced meteorological drought conditions in the December-January bi-monthly period. Below normal to near normal rainfall is in the forecast for the island for February to April. Near normal to above normal temperatures are expected for the February to April period. These conditions are affecting the National Water Commission's operations, as more than 260 of the enterprise's 450 systems are supplied by rivers and springs, and these are extremely vulnerable to drought conditions. The island-wide drought is severely impacting the storage levels at the Mona Reservoir and the Hermitage Dam. Other systems in other parishes are also being impacted. Despite the challenges, the NWC is committed to continue our service to you through the implementation of our drought resilience strategy. These include regulating the supply in the corporate area and in all other areas based on the nature of the system and the level of impact as part of a strategic management mechanism to ensure that the existing supply can last over a sustained period to benefit you, our valued customers. We are trucking water to the worst affected areas using the recently procured water trucks and other trucking resources. We are continuing the implementation of the non-revenue water reduction program in Portmore St. Catherine, following its successful implementation in Kingston and St. Andrew. This program targets reducing water theft, leaks, and other losses along the network so that more water is available for legitimate domestic, commercial, and firefighting purposes. Additionally, we continue to commission several system improvements in all parishes.
We get it out in our home, the kitchen, the bathroom. I feel good about it. I appreciate it very well.
These improvements include pipeline extensions, wells and tanks that are all helping to cushion the effects of the ongoing drought conditions brought on by global climate change and other factors. As part of the medium-term strategy, there has been the upgrade of the Spanish Town to Blake Road transmission main that will improve the supply to several communities along Spanish Town Road, Marcus Garvey Drive, sections of Central Kingston, and downtown Kingston. We are also looking ahead. A major public-private partnership agreement was recently signed to harness 15 million gallons of water per day from the Rio Cobre in St. Catherine to help augment the supply in Spanish Town, Portmore, and Kingston and St. Andrew. Drought has become an unfortunate reality for several countries across the world. Through an effective drought management strategy, we will endure. Go to our website, nwcjamaica.com, to see how you can help play your part by being water smart. The NWC, serving you in so many ways.
Looking for that next science project, one that will make a lasting impact, and one that's also economically beneficial? Look no further than the National School Tree Planting Competition. We're calling on all schools from early childhood right up to the tertiary level to sign up for this worthy cause. The school that plants the most fruit or ornamental trees will get $300,000. Visit the Forestry Department's website to submit your entries for a chance to win awesome cash prizes and awards. Don't forget to download the 876 Trees app and see the progress of each tree planted. Get those green thumbs working and let the planting begin. Entries close on February 28, 2023.
Brethren, the road signs make the traffic environment safe. The green light means go. Red means stop. Amber also means stop. Yeah man, it don't mean you must speed up. And get this, even if the light's on green, when the traffic is thick, don't bother move off and block the intersection. And please, don't stop on a pedestrian crossing. Look out for children, the disabled and the elderly. Follow the signs so they all can arrive alive. Be a good road user. Obey the road signs and look out for each other.
Coming in April.
Between January 1 and December 31, you are a parliamentarian or public official in receipt of total emoluments of $3.5 million or above, or you are appointed or perform the functions of a position listed in the Jamaica Gazette, December 14, 2022, regarding the Integrity Commission Act, you are required to file a statutory declaration of assets, liabilities, and income as at December 31. What to file? You're required to declare all balances and interest in all assets, liabilities, and income received by you, your spouse, and children below the age of 18, whether living in Jamaica or abroad. It should be noted that a person who knowingly makes a false statement in a statutory declaration may be liable to a fine not exceeding $2 million or to a term of imprisonment not exceeding 2 years. The Integrity Commission has implemented its zero-tolerance policy. All declarants are to submit all outstanding statutory declarations. Failure to submit a statutory declaration may attract a fine of not exceeding $500,000 or to a term of imprisonment not exceeding 6 months. The Integrity Commission has decentralized the collection of statutory declarations. Submit your statutory declarations for the previous calendar year securely within your organization on or before March 31 of the following year. Here's how. Firstly, complete your statutory declaration. Ensure you have entered the correct as-at date, for example, December 31, 2022. NA or C attached is never an appropriate response. Use none and list all required balances. Copy or print additional pages where necessary. Ensure all the sections are signed. A justice of the peace is required to validate your signature by signing, entering the date, location, and affixing their embossed seal. Attach the relevant supporting documents. ATM printouts are not accepted. You then proceed to your in-house collection point. Collect a statutory declaration envelope and security seal. Place the required information on the statutory declaration envelope, seal the envelope, and affix the security seal. Deposit the secure envelope in the Integrity Commission branded collection container or with your designated officer on or before March 31. Finally, enter your name and date of submission on the Integrity Commission log sheet. The designated officer should deposit the white copy of the log sheet in the collection container on April 1. Retain the yellow copy for the files and facilitate the submission of the collection container to the Integrity Commission. The Integrity Commission will register your statutory declaration and send you a receipt by email on or before May 13. After submission, the statutory declaration is examined for due completion and accuracy, where the Integrity Commission is satisfied that the statutory declaration has been duly completed, certification is done, and an advisory issued to the declarant. Submit your statutory declaration completely and accurately and get on the path to certification. For more information, visit our office on the 4th floor of the Sagicor Sigma building at 63 to 67 Knutsford Boulevard, Kingston 5, or give us a call at 876-968-6227 or 876-960-0470.
Jamaica, home of the resilient, passionate and hard-working. A people and a nation who have achieved and defied all odds, working to keep their economy growing, their country thriving, from investments made in innovative opportunities and exports demanded globally. We have a vision, now within our grasp, where Jamaica becomes the place of choice to live, work, raise families, and do business. We will not let go of this vision. We will grow. We will overcome these challenging times and look to the future with hope and positivity. These are special times. The world as we know it has changed, but home will always be in our hearts. And in Jamaica, you can always find a home. Think you know Jamaica? Look again. You will be surprised.
Greatness is in your bones.
I'm unstoppable. I'm a vulture with no brains. I'm invincible. Yeah, I win every single game.
We're looking for great things this season, and I know you believe it within your very core. And so we have committed to continue the support behind you and in front of you and beside you so that you can excel and you can do well and you can be your best self.
I'm unstoppable. I'm a vulture with no brains. I'm invincible. Yeah, I win every single game.
I've been in agriculture now 10 years in Jamaica and 15 years in Florida. Well, I got in agriculture because I have a deep-seated passion for agriculture and it's fruitful. I grow Scotch bonnet peppers, sweet peppers, pumpkins, broccoli, and sweet potatoes. Presently, I feed into the hotel chains in Jamaica. With each tourist coming here, everybody have to eat, so it would be best for us to be feeding them with locally grown produce. And this is my passion, and it's very fulfilling. So if you follow the guidelines and you have a true passion for agriculture, from the seed to harvesting it, it can be fruitful, and you put in a position where tourism is working for you.
Yes, walk right over there and drop it in the bin. Reuse that wastewater from your kitchen for the garden. Get your hands dirty and plant a tree. Farmers, hold off on the pesticides, especially near our rivers. Do your part to protect our watersheds so we can preserve the source of our drinking water. Every act to protect our watersheds counts. Start now.
Twists, turns, ins and outs. From the four corners of the earth, PBCJ presents Globe-Trotting Yardie with Carol Francis.
There are numerous ways of traveling across the city of Delhi.
Tantalizing, breathtaking and revealing, bringing you the wonders of travel from across the world. That's Globe-Trotting Yardie, right here on PBCJ, the People's Station.
an act called the Legal Deposit Act. And everything you write, everything you create, you should deposit a copy of it at the National Library under the Legal Deposit Act. So I want to use the opportunity to say to all of you musicians, the creative people, the writers in this industry, if you have not yet deposited your record, your songs, whatever you have done at the National Library, please do so. There's actually a fine if you don't. I don't know how many of you are aware of that. In the words of our theme, we come to catch the rhythm in reverence and praise. We do so realizing that while we are not totally out of the pandemic, we are nevertheless able to open up and reset the entertainment industry and cultural sector for the enhancement of the lives and livelihoods of creatives and the nation as a whole. We have seen the return of large events. This year started with Barris and Buju's concert, Intimate. We celebrated with the Tony Rebel at the 29th staging of Rebel Salute. And there is much more to come during Reggae Month. We come in the full knowledge that all that we are able to achieve is based on God's gifts of creativity and innovation. Through Him, the pioneers of our music were able to create this global energy called reggae. And reggae music has been recognized as one of the most dynamic creations of people of African descent that has fortified and brought together aspirations of our people, both here and across the world. I want to use the opportunity to say that those that the music has created wealth for, I ask them to be humble. Be humble and do not take it for granted. Because you can be wealthy tonight and be poor tomorrow. It's a gift, and we should take that gift with humility.
Crime and violence is infecting our youth. We must work together to rescue them from the gangs, engage them in productive activities, and safeguard Jamaica's future.
The proceeding was brought to you by the Office of the Prime Minister.
Your government is working for you. On the East Coast, there's the Southern Coastal Highway Improvement Project. The highway, which began in January 2017,
All right, well, before we resume the review of the matrix, then I would just provide an opportunity for any question, any comments in respect of the guidance provided by the chambers on the issues of constitutional law raised in the various submissions on the pre-charge regime. All right, I see.
No, hold on. Minister, just one aspect of it. I wanted to ask whether or not Mr. Foreman had any concerns after looking at all of this legislation and the way in which the European Court of Human Rights had interpreted the article, if he had any concerns about the time frame, the 6 months for pre-charge bail. Did he think that length of time was an issue when he examined the matter?
Thank you. I don't recall coming across any judicial guidance on that particular point. The general principle would be that judicial control is essential and that, broadly speaking, the less time there is for conditions to be imposed on the liberty, broadly in the more abstract sense of the person, the less likely it is that any problems might arise. But from the perspective of principle, the guiding light is that the judicial officer should should be in a position to oversee the questions of whether there should be detention, and if there is release on conditions, what those conditions should be. So that there may be some room for a time period. The committee, no doubt, will deliberate and consider whether you want to reduce the time period or not. But nothing specific to that question I can recall coming across.
Thank you.
All right. I believe we left off at page 19 of the matrix in our last meeting, and we were to circumstances in which bail may be denied at clause 7, and we were to pick up with the submissions of the Independent Jamaican Council for Human Rights and the Cornwall Bar. We had stopped, the record is showing, at the Norman Manley Law School. Well, no, yes.
We didn't read this part, though. We didn't read it. We didn't read.
All right. Ms. Wilkins, may I invite you to take us through as you had the last time? So on page 19, in respect of clause 5, the circumstances where bail may be denied, the independent, clause 7, page 19 of the matrix. Clause 7 from the Independent Jamaica Council for Human Rights. As it relates to the circumstances of discretion, empirical research, if done, would have shown that the multiplicity of circumstances set out in section 7 that may justify the denial of bail, as well as numerous more that are not so set out, would all be considered by a judge at some time or another. Indeed, most of these are already set out in the present Bail Act, which, contrary to the impression being given, is quite comprehensive. In this regard, there is a potential positive effect, as setting out these factors might provide the framework for a sort of checklist that both the suspect and the prosecutor could benefit from. It is, however, in the nature of the exercise of a judicial discretion that there are hardly any limits to the scenarios and the circumstances that determine how the discretion is exercised. To set them out in a statute as matters that a judge must or may take into account in deciding whether or not to grant bail could even found a view that the express mention of those matters might mean that other matters not mentioned should not be considered. That view, if accepted by the judiciary, would itself manifest an unwarranted encroachment on judicial discretion and risk constitutional condemnation, but a workable remedy might be found if Parliament considers providing clearly in the bill that the circumstances set out in Clause 5 are not exhaustive. Let's just look at the clause. So this is Clause 7 with a reference to Clause 5. Madam CPC, do you have a comment in this regard? Because I'm not seeing any words which would indicate that nothing else can be considered. In fact, I see at Clause 5, 6, 7, any other factor that the judge considers relevant. And I also see at Clause 7I, 7.3i, any other factor that appear to be relevant. So I'm not sure what it is intended to convey, because the provisions in the clauses no way indicate that the court cannot take any other matter into account. Madam CPC, may I invite comment from you?
Chair, it is as you have stated, there is that what we would call a catch-all provision at the end of each of the respective subsections to indicate that the judge could take into account other factors. So it's not limited.
Yes, so that concern actually is specifically addressed in the two clauses referenced, because there is the catch-all phrase for provision for other factors that appear to be the court to be relevant, to be taken into account. Any comment from? So we could note that the concern is already addressed in the clauses. Well, the recommendation was that as it relates to the denial or protection, the codification that the bill seeks to make of the common practice of denial of bail. Oh, that's another one. I'm sorry. So in respect of the concerns raised, we could indicate that the clauses already address the issue. You know, in earlier deliberations, I wondered aloud whether some of the submissions were actually informed by what is actually provided in the bill. And this is another example of that. The very issue being raised is specifically addressed in the bill, just underscoring the importance of ensuring that when comments are being made, it is not enough to just make general comments of concerns, but to look at what is in fact provided in the provisions under consideration to see how those concerns are addressed. Ms. Wilkins, you're ready to take us up now. We move to circumstances where bail may be denied on page 20. We had already gone through the JFJ, nothing from university. It's the Jamaica Independent Council for Human Rights.
Yes, that's what we did.
Oh, I'm sorry. And back over to 19, Cornwall Bar submission.
Okay. In relation to section 7.2, there may be concerns raised regarding...
Hold a minute, please. Member
I'm sorry, did we do the Independent Jamaican Council for Human Rights?
That's what we just did.
Oh, yes.
That's what we just did. Yes.
Okay.
Please proceed.
In relation to Section 7.2, there may be concerns raised regarding this provision and its incompatibility to the right of every citizen to be entitled to bail. While the wording of the bill does not explicitly preclude bail from being granted under the circumstances, there may be grounds for an argument that it infringes on or even removes the entitlement to bail. However, the entitlement to bail enshrined in the Constitution is not absolute, and so a denial of the entitlement to bail is not inherently unconstitutional or illegal. The entitlement exists unless sufficient cause is shown for keeping the accused in custody. Therefore, the question permeating would become, what is sufficient cause?
And that is a matter for the court to decide, or for the deciding authority, if what is placed before them amount to sufficient cause, having regard to the entirety of the circumstances of the case. The submission is noted in that regard, but let's see the recommendations.
The following are being recommended for Section 7. It is recommended, therefore, that the provision allowing bail to be denied for persons charged with murder be removed. It is suggested that this provision should be amended to impose, assert, and confirm the prosecution's positive duty regarding the evidential burden in order to escape any doubt of the burden being shifted, and reconcile the provision as best
as possible.
Yes, as best as possible with the Constitution. Rationale. Further to this, the evidential burden is on the prosecution to show that bail should not be granted, in keeping with the European Convention on Human Rights. The phrase self-defense does not arise on the prosecution's case does not suggest that this positive burden is being upheld, as it speaks to an omission. It implies that though the burden is not being shifted positively onto the defense to prove that bail should be granted, which is inherently a breach of his rights, it balances itself in an uncomfortable space between what ought and ought not to happen. Based on a literal and ordinary construction of the words promulgated, the prosecution would not have to uphold a positive burden to prove that self-defense did not arise, but rather the condition would be satisfied where self-defense simply does not arise in the prosecution's case.
Comments from any member? I can only say that from my time at the bar, and certainly my time as a prosecutor, it is always clear when self-defense may arise as a defense on the allegations put forward. When provocation, when other matters, there are some defense that you can set up independently of having any glimpse into what could. In fact, it is because some matters arise clearly or seem to arise why you can have plea bargain around taking a plea for a lesser offense. A defense may arise, but it may not be proved, because the general rule is that he who asserts must prove. But where that assertion is made. So there's a difference between the legal burden and the evidential burden. And the legal burden never shifts because a person is presumed to be innocent until he has been proved to be guilty or he has pleaded guilty. And that burden never shifts. And the standard of proof is beyond reasonable doubt. But there are some matters, evidentially, not legally no, where someone asserts something, and the rule is that if you assert it, you must prove it. And the proof is on a balance of probabilities at a lesser level. So even without someone saying anything, because you do have a right to remain silent, if doubt arises on the case for the prosecution, reasonable doubt, there can be no conviction, because conviction only flows if the evidence satisfies the arbiter of fact to the extent that you feel sure of guilt. So I'm not so sure that I'm fully getting what the Cornwall Bar is saying. The provision is not asking for a defendant to prove anything at this early stage. Not at all. Not at all. So a typical case in which the issue of self-defense may arise on the prosecution's case, even without a defendant saying anything. If two people were in a fight, someone attacked someone and you're responding, and those are the allegations in which death occur, as opposed to a situation where out of the blue, someone is shot and killed, for example, stabbed and killed. So there are circumstances where you would wish to hear more. A person may say, yes, I did it, but I did it because I was under attack and I was defending myself and I used no more force than was reasonably necessary. If it's an anticipatory attack, it's because you honestly believe that you were under attack. So I think the submission and the comments conflate a number of issues which perhaps do not appreciate that the provision is not saying that you have to prove self-defense. But I do not think that it is true to say that self-defense may not arise on the allegation. I mean, this happens in court all the time where you hear it say. So, but self-defense, once successfully established, is a complete defense. And no offense is committed in the circumstances where self-defense is asserted and properly proved. And even in this case, it is for the deciding official, having heard what is presented, to make the determination whether the matters set out in the provision actually arise. But I confess that, I don't know if it is just the extreme from which we argue many things. Any comment from any member? I don't know that we need to assert. No burden is placed. The provision places no burden on the defendant to prove anything. In fact, one of the reasons why a previous attempt to amend the Bail Act, a provision in an amending act, was struck down is because it had placed a burden on the defendant to prove why bail should be granted. This is not doing that at all. It's not doing that. Any comment from any member?
Chairman.
Yes. Member Jackson.
Yes. I don't have so much of a well, not a comment, but more question for my own how should I say, edification. In such cases, what would be the minimum condition that would satisfy a judge that I should be released bail? I should be released on bail. The circumstances being discussed. I am detained by the police. John Brown is detained by the police and brought before the judge. From a legal standpoint, what is those minimum sets of ingredients of criteria?
Sorry, Member Jackson, I'm not hearing you clearly. I don't know, it's coming across a little muffled.
Sorry about me. Yeah. Is it better now?
Go ahead. Please start again.
Yes, I was saying it's not much of a comment, it's more a question I'm asking, just for my own sense of appreciation. Someone brought before the judge, what set of minimum criteria or ingredients that I as a defendant, John Brown as a defendant, would have to meet? What is that threshold, minimum threshold, to be met to make bail undeniable?
You mean what amounts to sufficient circumstance?
Yes, the sufficiency.
Speaking generally?
Yes.
So the bill sets out some. So if you have information that the person is a flight risk and is not likely to return to stand their trial, usually it's indicated in perhaps no fixed place of abode, likely to go abroad, matters like those. You may have circumstances where it may be, if in practice and case law holds it out, if the allegations are strong on the face of it, where the likelihood of a conviction is high, depending on the kind of offense, murder, for example, in those circumstances is highly unlikely. And from what my information, the research shows, bail is not usually granted in those circumstances. What happens is that many matters take so long to be tried. So whereas initially there was proper justification to deny bail on the strength of the allegation or any of the many other matters, but then having regard to the length of time that it has taken for the trial to get off the ground, many people have been granted bail in those circumstances. But as a general rule, my understanding, I mean, putting the law aside, but speaking of practice within the jurisdiction, those matters that are flagged from time to time about people on murder charge being granted bail have to do with the length of time that the matter has been pending. Sometimes witnesses have disappeared along the way, any of many matters. But as a general rule, the offense of murder has always been treated as a very serious offense. A life has been taken in the circumstances.
If I may, just to follow up on the point, but two points. One is sufficient information. Is that information has to be buttressed by evidence in order to substantiate it, rather than a police officer just say, I hear say, or I believe this, I believe that. Those beliefs have to be substantiated by evidence, put before a judge, or just the police officer says he believes.
So the practice has evolved over time. To the best of my knowledge, the courts do not find it sufficient for a police officer through the prosecution to merely say, I believe that this is so. The assertions have to be substantiated, and in fact, bail hearings are substantial hearings in the court these days. part and parcel while matters sometimes take so long in a given day, because it's not just a judge, I oppose bail for this person. The court has to be provided with proper reason that would meet the legal threshold and reasons that can be and information that can be substantiated. It's usually a contested space.
See, Chairman, I asked that question in the context of, the state, initiating with the state making the allegation of the offense. And I'll preface that comment further just to say, I have a very strong feeling about when the state acts against a citizen. I believe there should be an overbearing of evidence to support the state acting against an individual. Very different than I go to the police and say, John Brown cut me or shot me or threatened me. And I'm a witness, and that is kind of very clear. There is an accuser, somebody to be a witness to what is being claimed before the court. And a police officer, in this case, an officer of the state, goes before the case and says, I believe this and I believe that. And I say that, Chairman, against the overwhelming sentiment in many communities of certain profile across the country, having those experiences or making those claims. Because the truth of the matter, Chairman, for us to successfully fight crime, we have to do our best to enlist the unbridled, unreserved support and cooperation of ordinary citizens in every community, from all the communities across this country. So I'm very careful about any angle or leverage that can provide for almost arbitrariness in terms of detention and subsequent denial of bail when those detentions are made. That's why I'm really going down this road. I want us to make sure that we as best as possible, insulate against those occurrences. The truth of the matter, Chairman, we who sit here and deliberate these legal provisions, we are not the one going out in the street to execute it. There are other persons. And so we have to make sure that the safeguards are in place against those who are not truly guilty of the alleged offenses for which they're brought into custody and subsequently brought before the court. So those, I don't know if you get a sense of exactly where I'm going. What is it that is motivating my concern here?
I think I have an appreciation of it. I said to Senator Scott Motley earlier that what helps me to think through these issues is a particular approach. So the provision for reasonable suspicion that an offense has been committed is the antidote to arbitrariness. So you're not being arrested and detained just because I feel say. There is a standard of reasonableness, reasonable suspicion, and that has been pronounced on. In respect of matters going before the court or other competent authority, we have to take some consolation in the fact that these are trained people. All of our judges, there is a professional qualification and an experiential qualification that have to be met before people are qualified to be appointed as judges. And even though we may have real concerns about how duties are performed, we have to be consoled that it's not an untrained mind that is being picked up and placed in positions to adjudicate on these matters. These are people who are trained in the law and should understand the standard of the law. But even so, the system recognizes that errors can be made, and that is why you have reviews, and that is built in the law. And then you have appeals also, and there are grounds for appeal, And I think that we will never be able to cover and address every concern. Many of the concerns raised, I think, have to do with how the human being behind the office or to whom the power has been entrusted and who is given, to whom the functions of office are entrusted, how they operate. And I think where you and I are on common ground, Member Jackson, is that we will have to do a whole set of reform around the people who discharge the functions of state. Because even when we legislate at the right constitutional standard and we put the checks and balances, God forbid if we come upon someone who does not take the job seriously. And that's why I also share the concern about holding the people to account. It's a lot of work that is before us, because in many cases where there are concerns of abuse, it's not that the law itself is unjust, it's how it is enforced and how it is implemented by the people who hold the offices. And as we go through this exercise, I find myself thinking through what is the real problem and where does the solution lie? Is it a problem in the law? And even if it is a problem in the law that we must legislate, as we are tidying up the Bail Act, because there were, the way it's arranged, readability, all of those issues. That only address one set of concerns. At the end of the day, the people to whom powers are entrusted will have to do the work. And there is a standard, and they must know the standard, and they must honor the standard. And that is why the law allows for appeals, allows for reviews, etc. And ultimately, there should be, within the category of officers, a way if you have any particular individual being serially disregarding of the standard, that must be met in their action to be disciplined and dealt with. But that is where we have been weak.
Chairman, I appreciate those comments you make, and you emphasize to a great extent the training that has been extended to our judges. And one would argue in the same way the training is extended to our lawyers who defend, or would be there to defend persons appearing before court. There are 2 points in that regard. And this is where you and I kind of have a little space between us, Chairman. You oftentimes refer to the provisions in the law and the fact that the points can be raised before the judge. For many persons, excluding you and I, or many like us, who might be able to access legal representation, many ordinary persons out there don't get the benefit of that quality input in the appearance before the judge. And that's the reason why I believe it is imperative that all steps be taken to avoid some of these things that are unintended having to reach before a judge, because many can't get there with quality of training and competence which is required. Let's be frank. You have good lawyers and you have poor lawyers. You know, colleagues of yours in the profession underscore that to me from time to time. Right? I have seen some of it manifested myself. Right? That is the reality. And when you have persons in our jurisprudence that are presumed to be innocent, we want to make sure that the least obstacle for proper and just intervention by a court, by the legal system afforded that person. So I say all of this to say, in as much as we can sieve out some of those things that will cause the person to have to go to court to make a point, then we ought to do that. That is the core of my concern. I say that against the background, Chair, and you may have heard me say this repeatedly in this committee and others that both of us happen to share in. The whole question of issue of denying one's freedom, right? I take it extremely serious, and it can't and ought not to be done. I wouldn't say willy-nilly, but with the absolute certainty of justness in so doing. But those are the things that lurk in the back of my mind when it comes to these matters. Somebody's freedom. I cherish my freedom most, more than anything else. Take away everything I have, but my freedom is foremost. And I have that sentiment. I think that many, if not most, persons out there, Jamaicans, feel the same way. And we as lawmakers, we have a duty to try to serve that as best as possible. That is the motive behind these concerns that I express.
May I add something to what my colleague has said? You know, it's so very important for us to balance what it is we want to achieve in terms of a society where justice is done, in the sense that those who commit offenses pay for it. And that we through our legislation, indicate how seriously we view certain offenses by the kind of penalties we impose. But let me tell you what I wrestle with all the time. When I started my practice, I did solely criminal law. And one of the things that struck me was how quickly somebody was transformed by jail and transformed negatively. So that if they were apprehended, arrested, and taken into custody, they were frightened, they were scared, they were nervous, they were anxious. But within another 3 weeks or so, if you went back to see them, you were seeing a totally different individual because the environment had changed them. And part of what I am thinking, even as we're discussing the pre-charge bail and other things like that, when we were doing the states of emergency and the long periods of detention, was who are we really achieving what we want to achieve? Are we really achieving a society where people have respect for the law? Are we really dealing with the level of criminality that we see? Are we suppressing the level of criminality? Or are we sometimes unwittingly creating more criminals? It is a challenging thing for our government to have to take into consideration. These are facts, social facts that we have to absorb. And Madam Chair, none of us want to see Jamaica in the state that it is in now. It is true, as you say, that all the systems are there, the appeals, the judicial review. But then when you look at our system and how long it takes to get to a trial, how long it takes to get to appeal, how long it takes to do the review, I think that sometimes when we are passing the law, we have to actually put the safeguards in the legislation. And I say this finally, Madam Chair, every time I think about it, I remember an account which was given about during the states of emergency. Council said, and this has been said many times, so I feel free to repeat it, that there was his client had a tenant who was a police officer. And when his client increased the rent, the policeman made a report against him that he has stolen some goats. It was totally fabricated. It was vindictive and malicious. But in the meantime, the landlord became a victim because somebody had power over him and was determined to take advantage of that power to abuse the process. So, Madam Chair, when I'm looking at it, what I am trying to achieve, what I'm trying to see is how we can have this delicate balance of rights.
May I ask a question of you, Senator? How do you think such a police officer should be dealt with, and what rules do you think should be in the constabulary force to deal with any police officer who uses the cloak of the authority of the office of police to deal with?
I certainly don't think he should remain a police officer.
Right.
I think that his approach
and what you think,
to dispense his duties.
Just hear me out, because I think that all of us should be outraged by that. Outraged. You know what happens invariably when we come to probably say, let us look at the standard of conduct that is expected of police officers. And if they fail to meet that standard, whether they should remain in the force because their presence would undermine confidence in the police service and the entire integrity of the force is brought into question through the conduct of a single officer. I wonder if we're going to get hues and cries about a system bashing a police officer or bashing someone. I mean, these are matters that we have to contend with. So we will all agree that where it is shown that someone uses the authority of their standing with the state for personal gain, should not. What you really are saying, using that as an example, is that we will seriously have to look at the quality of the people who are entrusted with ranks within the police force, and once they conduct themselves in a certain way, we have to deal with them quickly. So the speed with which we desire matters to be dealt with sometimes is not borne out by the steps that have to be taken to arrive at a conclusion on the matter. And I think we really will have to sit down. Thankfully, you're part of the committee to review the Constitution, because when we get into the later phases, especially matters relating to the public service and the civil service, and what should be the standard of entry, what really do we want from people who represent the face of government at their desk? I've always said that the face of government you see is going to be the face of the person discharging the functions of government at the particular time when you engage with government. If you have a good experience, you'll have a good day. And if you have a bad experience, it doesn't stop with a particular person, but the entire system is brought into disrepute. So the concerns and the examples cited, the concerns raised and the examples cited, speak to deep-seated issues. Again, I ask, how many of them can be addressed in this piece of legislation that we're dealing with, and whether those concerns are properly borne out here? The day we stop expecting that the people who hold offices should be held to account and should be expected to perform at the standard required of them is a day, and I think probably that day has come and passed, where everything pops down. So again, it helps me to think through the issues in a particular way. I think if we all accept that constitutionally, as much as we cherish and revere, like you and you, I guard my freedom. But in guarding it, I understand that in certain circumstances, I may be deprived of my freedom. I also understand that in circumstances where I am lawfully deprived, there is a standard that must be met in how I am treated. So if I am not so treated then there are consequences. True, it takes time, but I don't know that Jamaica is the only place where it takes time to get matters done before the court. I recently had experience to look at the Canadian courts and hear of just the level of delay there. I was looking at a particular state in the U.S. So sometimes we magnify our problems, believing that we're the only place with them. Now, it is true that when it takes way too long to have matters resolved. But to say to Member Jackson that the state does provide duty counsel at police station, the state does provide legal aid. And as you rightly say, the standard will vary depending on the approach taken by a particular counsel. Now, I don't know if the expectation of the state, it's a realistic expectation on the state to say that you must demand that every attorney operate at a certain standard. But you must set to the standard and ensure that people don't fall below it. It doesn't mean you can't rise above it. So there are many, many problems, but how many of them can we address in this Bail Act? So on the particular provision...
Madam Chair, just permit me to say one last thing. Please indulge me.
Yes.
You know, recently there has been a grave distinction drawn between the elected and the unelected. And senators are always being reminded that they are unelected. Therefore, they do not represent the people and the people's will. And I believe that those who are elected have a duty to all sections of the society, so that they have to balance the mandates which they have. And it's incumbent on them that wherever possible, taking into account the Constitution, taking into account all the laws, taking into account the structures and the system, that they have to set the tone that they require the country of fairness and of being balanced. I remember when Carl Rattray used to say that the problem we had was that we needed to create a more gentle and caring society. And it's the legislators who are going to play a significant role in that. And they can do so by taking into account every side when they are legislating. Say, for example, if the person who is administering this is somebody who does not understand or does not take their responsibilities seriously, how can I create legislation that in a way gives life to that thought? Thank you very much, Madam Chair. I felt I needed to say that.
Well, I can only speak for myself and my colleagues. I believe we do take our responsibilities seriously. And if we cite some of the examples that we're discussing, it is why we're pushing the boundaries to ensure that where there is reasonable suspicion that someone has committed an offense, but more time is required to build out the evidence because of the harsh realities in the society, such a person does not languish in custody. And that under no circumstance anyone languishes in custody unless there is sufficient cause meeting the legal and constitutional standard for keeping them in custody. I think it's a good example of demonstrating a high level of sensitivity to the issues in the country, because we have a high crime rate, which means that many people will be reasonably suspected of committing the offense where the crime is alleged. And with the high number, we shouldn't be locking everyone in custody. And so once the threshold, the constitutional threshold is met of reasonable suspicion that an offense is committed, but you need time to deal with the other aspect, that no such person languishes in custody unless sufficient cause exists. So I believe that this very bill is a good demonstration of consciousness of the issues and the plight facing the people, and in particular, the very disadvantaged among us. So we're not waiting. Once that legal threshold is met, when high crime exists, you know, it means that there are high number of people committing the crime. Sometimes it may be the same people doing a lot of the same thing. But this bill that we are reviewing, to my mind, is a good example of showing our sensitivity to those who, for whatever reason, may be reasonably suspected of having committed an offense. Because it's not just their rights that have to be taken into account, but the people whose rights have been impacted by the conduct of the suspect, of the defendant. Because if we use the example of murder, the murder suspect has his rights, but the deceased is no longer able to enjoy any rights. Family members, the enjoyment of their rights may be impacted by the death or the killing of that person. If we live in a community where guns are brandished left, right, and center, or gunshots are being fired, those people may not be able to enjoy the right of the liberty of moving around freely. So this bill, not able to address every single issue, but to my mind is a good demonstration of appropriate sensitivity to issues. And again, it's not going to be us who will implement it, and that's why, as far as possible, we enumerate factors to be taken into account to guide the judge's discretion. Because the law says, you know, although the judge is learned, the judge must demonstrate that in adjudicating on a particular matter, the relevant principle of law was foremost in his or her mind at the time.
You know, Chairman, when I hear you make that analogy about victims and those who appear that are detained, regrettably, it gives a clear appearance as if a detained person is a guilty person, and therefore the presumption of innocence is.
I don't know why I'm not hearing you properly.
Any better? I don't know. Any better?
The stenowriters, the recorders are not hearing either. So, I mean, I thought it was my ear malfunctioning, but the Hansard reporter is actually indicating too that he's not hearing clearly.
Obviously, technology is failing us.
You were saying that it appears that people who are accused are guilty. Not at all. That's why you have process. That's why it says that you don't come to guilt unless you go through a process. But we have to get to a place of understanding that, and I think Mr. Foreman, in his analysis of the law and in his research, brought it home clearly that once that threshold is met, other things are engaged along the way. So, you know, it's just a lot of learning and a lot of education that needs to take place around many of the issues. Because the law is not just for lawyers, but you have to be a trained lawyer. You have to be a trained lawyer to practice the law.
But Chairman, be mindful, the law is one thing, but it's fair and just is another thing. They're not quite the same all the time. So while the thing might be correct to the teeth of the law, it doesn't necessarily mean that fairness prevails in the circumstances. I am not going into what the law is or isn't. I am concerned about at the end of that process, or even during that process, that fairness and justness prevails. That's where I am. And when I hear the parallel, which you make about the rights of the accused, and because the rights of the accused have to be preserved, these things have to be done. The person who is detained is not innocent of any crime yet. is merely a suspect, regardless of what they. Everyone who is detained.
Member Jackson, remember the law doesn't say that you can only be detained and deprived of your liberty if you are guilty. It doesn't say that. But as a legislator, just give me a moment. As a legislator, I believe it's an important distinction to know and understand. It doesn't say that to be deprived of your liberty, constitutionally and lawfully, you must be guilty of an offense, because guilt only comes after a process, even if it comes by way of a plea. It comes after a process. What the law says, not only here in our domestic law and in our constitution, but in the international instruments in the community of nations.
No, if you
it's important for that to be understood, because we keep conveying the impression that it's hold a minute. I will give you an opportunity.
Allow me to complete my point. Maybe it would be necessary for you to make that point. All I'm simply saying, notwithstanding what the provisions of the law are, in getting to that point with those provisions, I am merely saying that there are some things that we must always seek to ensure that they are satisfied. That's all I'm saying. I'm not challenging what the law is or what the provisions of the law. But remember, we don't just get to the provisions. There's a process that gets us there. There's an exercise of judgment. There are activities that persons in the process engage in or don't engage in that get us to that point. And that is the reality of many persons out there. Many persons who are not ourselves, right, are the ones that oftentimes fall between those spaces, those gaps.
In that case, Member Jackson, we don't disagree. We don't
what the
disagree.
knowledge of the law is.
In that case, we don't disagree. And even going back to the example cited by Member Scott Motley, part of the wisdom of separating the arresting officer or an officer involved in the investigation from the decision to grant or withhold bail out of court is precisely to enable a neutral arbiter to bring judgment on the matter, because the officer who is arresting or investigating may have his own cause to serve. So again, we have exemplified in this law a consciousness of some of those issues that need to be taken into account.
As I will say, on that matter, I rest my case.
I don't think we disagree, Member Jackson. Not all of the real concerns can be addressed.
That is true. I don't think we intrinsically disagree.
Yes. But it's this law that we are reviewing, and we are reviewing it again. Certain things.
This law is this law. And this law will affect persons when it is enacted.
Yes.
I hear reference about.
But remember, it's making life better, not worse, for those who are. Our duty suspected or charged
is to make a good law, a better law, and to make a better law the best law it can be at all times. So it's a dynamic process.
Yes, well, I think there are significant improvements on what currently exists, clarification, etc. And to that extent, it makes it better. We will have to depend on the other players. We're only passing it. We're not the ones who will interpret it afterwards. That's why we're trying to make sure that what we intend it to be is clearly set out in the language that we use. And that's why this process of review is important. That's why hearing from others about their concern, bear in mind, as I say, it doesn't matter how legitimate the concern is. Not all of them can be addressed in this avenue and in this bill. My duty is to ensure where we accept that a concern raised is legitimate and requires some response, that I convey the message to the relevant part of government. Because government is not a one-man show. And no single office, not even the Prime Minister as head of government, can step into some places and exercise the function there. Otherwise, It's ultra vires and can be struck down. And I think that needs to be understood. Many people think that because you're a member of parliament elected, you have power over everything in government and can do everything. Quite to the contrary. Quite the contrary. Even when you sit as a team with members, each is assigned their fair share of it. Even in sports, the striker can defend generally, might help out. The defense is not the striker kind of thing, even though you may end up scoring a goal, but each person has a specific role to play. And sometimes that is forgotten, that no single person can do everything because the responsibility does not reside in a single place. All right, so we note the comments of the bar, and I believe, and then we can move on to the next provision.
Yes, Jamaica Bar Association. The following are being proposed about section 7(3)D and E. For section 7(3)D, it has been recommended that it be removed entirely. We must bear in mind that a defendant before the court is innocent excuse me, until proven guilty. The fact that a particular offense is prevalent in the community that surrounds the scene of the alleged crime is far too prejudicial to a defendant who is considered innocent at the time of such consideration. In section 7(3)E, a defendant's associations should be removed from consideration, since it is the law that a person who is not considered guilty of a crime merely based on his associations, such a consideration for the purposes of bail would be unreasonable and prejudicial to a defendant. Continue.
Let's just see.
Okay.
That's one recommendation.
Yes. Jamaicans for Justice.
There is a verse in the Bible which speaks about bad company corrupting, and it just jumped out at me as I heard that.
Well, show me a company and I'll tell you who you are.
Well, you know, we have many examples of concerns about people being led astray. It's just one of the matters that you take into account, because sometimes you hear the defense raised or the point raised in court, and I can tell you many examples for the almost a decade I sat in the People's Court. Judge, bad company this boy keep, him a good boy by himself, but go to school and get caught up in bad company and go down the path, beg you treat with him a little differently. So the reading that it is immediately prejudicial is not necessarily so.
Madam Chairman, with all due respect, I don't think that didn't just jump out on you, right?
You mean the Bible verse?
That didn't just jump out. That didn't
As
just
iron sharpeneth iron? Which one you think didn't just jump out?
The one about bad company. I don't think that just jumped out. I think that was deliberately inserted. Anyway, take yourself with
Member Jackson. Yes, proceed. The law recognizes common design also, and the act of one becoming the act of the other. This is not just unique to Jamaica.
So
Chair,
yes. That provision is actually in the law now.
Yes.
What is new is the
prevalence.
Yes. So I think that is the one.
But I remember again when I was a judge in St. Elizabeth. I'm trying to remember the name of the community where just about every house in the community was broken into. And when a defendant came before the court, the members of the community also attended. And while the defendant was before the court in respect of one house, many were saying, Judge, everybody in the community is a victim of housebreaking and larceny or whatever is taking place. And I wonder, should the court not take into account the prevalence of the type of offense? It doesn't mean that the particular defendant before the court committed the offense in all of that. But again, I mean, what is the harm in the court taking into account the prevalence of the type of offense? What is the prejudice? In fact, I think it's a sensitive and proper approach to look at what is happening. It's like, you know, I throw it out for members to make their comment. All right, we can proceed.
What is the conclusion for 7.3D?
To take out the association, etc.?
No, that's E. D, the recommendation is for its removal. So is it that it's not accepted? I'm just not accepted. Okay. Similarly, 7.3E.
Well, we can also note no, because it's a provision that currently exists in the law.
Yes. Okay.
Yes.
All right. That's that from there.
So considering an issue doesn't mean that guilt results on that issue alone. You know, it does. You don't move from a consideration of that straight to a finding of guilt. Next.
Jamaicans for Justice. It is being recommended to amend Section 7.3 as follows. Remove subsection D. And
That's
subsection
D
D
again
would
is
be
the
the
prevalence,
same provision. Amend subsection 1. Let me understand this clearly.
J. Looks like J to me.
Well, it said, or I.
Oh, amend 1 and 2.
And one of it's I2. Where it's speaking
Yes,
about
I think it's
remove
I2.
the reference to the wider society.
Madam
It's-
Madam CPC was coming in.
Yes, it's I2 on, wait.
I2, because that's the one that contains a reference to the wider society.
It's I2?
I2.
Me too or I2?
I2, the sense of peace and security among members of any household or community or the wider society will be undermined or jeopardized by the release of the defendant on bail.
Boy, if we don't consider that, it's which place that someone was on the loose? Because in this, you know, people can kill and mob killing can take place.
I think the issue was the wider society and the difficulty of determining exactly what constitutes the wider society. It's more the words and having a very clear and specific understanding as to what the words mean or to what the words refer.
Well, to the extent that sometimes people move. There was a case that was on where the allegation was that the offense of rape was committed in one place, and then the person was moving through so many places. The concerns were not limited to the small community, but to the wider society, you know. But we can look to see if there is a better way, but I do think the concerns.
I don't know if the CPC has and can assist in providing some specificity.
Perhaps deleting wider and just using household, community, and society.
That would,
Madam
I would,
CPC?
Yes.
No, why?
Madam Chair, what was your idea in suggesting removing wider society? No, just this. Wider versus
the society?
Yes.
Ms. Wilkinson said the concern was about the use of the term wider. But it means wider than the particular household and wider than the community, so it would have to be read in that context.
So,
but these are phrases that present difficulties.
Well, let me hear what the CPC is saying.
Yes, I will.
Well, Madam Chair, I was wondering, normally in this sort of case, we would really refer to public security. If that is the intention, then just to refer to society in general. I think the more usual term is to refer to public safety or public security.
Well, I know the household is a particular matter, of particular concern, because you have issues of abuse, you have issues in relation to sexual offenses against children. So that very focused consideration. You're talking about public security for wider society?
I'm suggesting removing the reference to household or community, but we could have spoken about any household or community or members of the public.
Okay, I think it would achieve the goal. So we will. Can we get a sense of the rewording then, Madam CPC?
So it could read, the sense of peace and security among members of any household, community, or the public. Among members of any household, community, or the public.
Okay, just check that again. So the community wouldn't be the public?
No, well, the public is the community is a subset of the public.
As the household is a subset of the community.
That's
all right. May I suggest that you consider the wording a little more? All right?
Sure. It's subject to refinement.
So we can say, what was we must amend to remove wider society. So we partially accept the recommendation to amend I2. So it's partially accepting the recommendation to all right.
Continuing. Make specific provision in reference to subsection K for the treatment of mentally ill persons in custody, including strict guidelines for the review of their custody, particularly in cases where bail would have otherwise been granted if not for their mental infirmary. Make particular provision for the training of officers to oversee their custody and for a psychiatrist to oversee their mental and physical condition at regular intervals while in custody.
I don't know if that is a matter for the Bail Act, because the Criminal Justice Administration Act, I think, deals with persons in custody around fitness to plea and so on. Yes. So we would refer where I think the provisions exist in law, you know, but it's how they are implemented and enforced, borne out by a report from the judiciary not so long ago admitting institutional failures to act in accordance with the provisions of the law. So I'm not sure if the issue is one of inadequate legal provision, but implementing and enforcing what is in the law.
Madam Chair, the point immediately before that, on page 21 of the matrix,
Yes.
remove subsection J. Did we take a decision on that? Did we?
Which one? Which one is that?
The one right above the mental health one that you just mentioned.
Well, that is a policy matter for this bill that...
Agreed, Madam Chair. It's just that I think we stepped over it.
Oh,
right.
sorry,
So that merely asking for it to be removed without even a reason to form the basis as a denial, that's a serious policy consideration that the court is to consider those matters in light of what is happening, the peculiarities in our society.
Oh, J was missed. Yeah.
And it is the evidence that the court would consider that it was used in commission of the offense. Earlier, Member Jackson cited with concern an allegation, for example, that someone was chopped up or threatened, and what would be the required threshold. If someone alleges that he or she was chopped, one would look for evidence of a wound, and then you would require a medical certificate from a doctor to say how serious it is. You know, the issue of a threat is a little different because it may or may not be spoken in the presence of others, but we also know of many examples where people have died, and in the course of investigation or trial, you hear that they were threatened and either the threat was not taken seriously and it was carried out. So again, I have to... Systems, institutions, even though they break down, we still have to have some faith that the people will honor the standards, and where they do not, they're held to account. But we certainly can't. Sometimes examples are cited, and if we just pause and think through a little, it becomes clear what you would expect to be interrogated in order to take you from point A to point B.
But Madam Chair, I think in addition, it's consistent with government policy.
Yes.
And as such, it would be almost hypocritical to not have this here. So it is very important. I just brought our attention to it because I don't want it to ever be said that we purposely overlooked it. And Madam Chair, I think also we have to look at the situation in Jamaica with the use of firearms right now and what it causes on the society. So it is a very necessary, I'll go as far as to say it's almost a necessary section to be included, clause to be included.
Your comments are noted, Member Campbell Rodriguez. If we have no other comment, then I take it that there is no support for the deletion of that provision. Simon, I see you're picking up for... It may be a little difficult to hear you, though, with a mask, you know, and since no one is immediately before you, beside you, would you consider taking it off to read? Because the reporter has to hear. Thank you.
Reading for the comments from the Jamaican Bar Association.
May I ask you to just project a little louder?
In relation to sections 7.4 and 5B, the recommendation is to repeat a concept from the existing act by giving the deciding official the power to deny bail for the defendant's protection. We submit that the adult defendants who are of sound mind should be entitled to decide for themselves whether they are safer in or out of custody, and that their decision over their own safety and life be afforded respect and precedent by the law. This is within the defendant's constitutional right to liberty and security of the person, which included their autonomy to choose and do as they please with respect to their own life, insofar as it's not a crime and does not impact upon the rights of others.
So again, well, let me invite comments from committee members on this. So the proposal is that it is within the defendant's constitutional right to liberty and security of the persons, which include their autonomy to choose and to do so as they please with respect to their own life, insofar as it is not a crime and does not impact upon the rights of others. Let me hear comments of members as anyone decides whether. So a permissible exception or a permissible deprivation of liberty is for the protection of the person. And in respect of a person suffering from mental disorder or addicted to drugs or alcohol, where necessary for his cure or treatment or for the prevention of harm to others. The provision says what? The defendant's mental health profile, and in particular whether the defendant's mental health state renders it likely that danger is posed to any person. Right, so that's K, isn't the K we're dealing with? 7.4, yes. 7.4, bail may be denied to a defendant who is charged with or convicted of an offense punishable with imprisonment if the deciding official is satisfied that the defendant should be kept in custody for the defendant's protection, or where the defendant is a child for the child welfare. So that depriving someone of their liberty for the purpose of his or her care and protection, that person who has not attained the age of 18, age of majority, is specifically provided for in section 13(1)(g) of the Constitution.
For
14(1)(g), yes. Yes, and keeping someone in custody for their protection. These are matters that, the judge would have to decide based on what is before the court in the circumstance. So they're asking
having regard to the conditions in today's jails, ma'am, that's Hobson's choice.
Sorry?
I was saying that I was thinking about the conditions in the jails. And the prisons, because it deals with whether conviction, which charged or convicted.
Let me just look at it again.
Yes, I'm looking at it. It says that bail may be denied. Yes.
4
Sorry.
And 5B. 5B says the deciding official is satisfied that the defendant should be kept in custody for the defendant's protection, or if the defendant is a child, for the defendant's welfare. So they're saying in respect of those provisions, which are in the current Bail Act, by giving the deciding official the power to deny bail for the defendant's protection. Okay, so they acknowledge that those provisions are currently part of the law. Yes. We submit that adult defendants who are of sound mind should be entitled to decide for themselves whether they are safer in or out of custody, and that their decisions over their own safety and life be accorded respect and precedent by the law, This is within the defendant's constitutional right to liberty and security of the person, which included their autonomy to choose and to do as they so please with respect to their own life, insofar as it is not a crime and does not impact upon the rights of others. So it's not saying that they must be denied, but it does say that the court would have to assess. I am not seeing the harm in the way the provision is worded, nor am I seeing that it is not open to a defendant who may want to say that is so. Let me hear from others. I know we have had horrible examples of horrible examples of, safety and security.
Chairman, I was just thinking about the young man who was set on fire in custody.
Yes.
Do you remember that instance?
Which of them? Set on fire in custody? By whom?
By the fellow prisoners who videotaped it and sent it around.
What a horrible act.
No, there are some horrible ones that have taken place, and it just brings to mind. I don't have a strong feeling, but I'm just thinking about all the stories that you hear of the abuse and the attacks on persons in prison.
Yes.
You might not know that it is unsafe. You might actually think that you're protecting the person. But when you hear about the control which persons have from prison over the rest of the population in terms of the instructions which are given to harm people, I'm just reflecting and saying,
Yes, me too. So the case of the child we have to treat differently,
yes.
Right?
You notice I didn't mention the child at all,
right? Because
I can't think of appropriate circumstances.
But insofar as is not a crime or does not impact upon the rights of others, it's not a matter that is easily determined without more. But I'm not unsympathetic to the view to say that if there are concerns about my safety as an adult and the need to protect me, perhaps it may be wise to allow the court to consider whether that protection can be done outside of state custody and allow me to choose. It's a hard call for me, to be honest.
I think somehow, when I'm reflecting on even like the witness protection program, which is where it's a witness, not somebody who is charged, who is put into protective custody, which is an altogether different arrangement.
Yes.
But for a judge to determine that this is in your best interest that you remain in custody is stretching me a little.
Well, it's not a new provision, and it's not a unique provision.
That, Chairman,
and I have seen. Let me tell you where I have.
The courts say,
yes,
it's only when a provision is challenged that the courts scrutinize it. It can be there in legislation. It remains there. It doesn't make it right. But if it's not challenged, then the court can't take any decisions about it.
I have seen the provision in action many times, many times. And on the flip side, I have seen where persons who have been detained in custody have been met upon harm. There are many examples of that. So this is not to say that there is any guarantee that you're in custody and harm may not come. But there is a standard for detention that is set and how you're to be treated. So there is an incarceration standard generally put at because it speaks to not just charge but conviction. So there is a standard here at 14 14.3, let's see. Let me just look back on it. Arrested, detained, that 14.1. There is a standard: a person who is incarcerated is to be treated in terms of in a manner that is in keeping with his dignity as a human being. That's a provision I'm looking for. Maybe it's at 13. Let's see. Mr. Foreman, you can help me out there. The one which speaks to standards of incarceration. So there is a standard around arrest or detention and the entitlement to communicate, to be visited by a spouse, a partner. Why am I not seeing it now? It's at 14. 14.5. Any person deprived of his liberty shall be treated humanely and with respect for the inherent dignity of the person. So that is the standard that is prescribed. At some point, we may have to flesh that out in ordinary legislation. And then you have the person who is arrested or detained, having the right to communicate with and be visited by a spouse, partner, family member, religious counselor, or medical practitioner of his choice. And then what should happen at the time of arrest or detention? To be informed in language he understands of reasons for the arrest or detention, and then where he is charged, to be informed forthwith in the language which he understands of the nature of the charge. And just to say, this is another example of a provision which treats a pre-charge situation different from a charge situation. I mean, specifies. So 2A, B, and A and B speaks to the mere detention, and then C goes on to specify that where the charge is actually made. So another example of the contemplation of pre-charge, post-charge, conviction situation, because the reference to incarceration is more than detention or arrest. That's where you are sentenced, to my mind. So though not clearly set out, it's featured in the Constitution at Section 14.
But, Madam Chair, in addition to that, I seek guidance on this thought, because it's a mere thought. The Mental Health Act, Section 15.2, where it speaks to the fact that, and I'm aware that this is one of those pieces of legislation that may need review in the future, but as is now, where it speaks to the fact where an offence is committed by a person who appears to be appears to a constable on reasonable grounds to be mentally disordered, the constable may, where it is necessary to detain the person until he is brought before the resident magistrate, detain him in a lockup. So I think there is other legislation that supports what is in this current legislation. I don't know, Mr.
So, you know, I have always expressed the view from my time in the criminal justice system on the bench as a prosecutor that people who are mentally unwell should be treated in the health system and not in the criminal justice system. And it's taking us a long time to get to there. But we have made some progress along the way.
Madam Chair,
then when you hear of the mental health profile of the country, but what needs to be understood from the purpose of this law is that if you are alleged to have committed an offense in circumstances where you're mentally unwell, you're suffering from a mental disorder, you may be kept in custody to prevent you from harming yourself and others. And I think that is what needs to be understood. Right.
It is outlined here in the Mental Health Act as well, which is the point I'm making, that supports the idea of it being in this piece of legislation, because it is in the Mental Health Act as something that is acceptable and should be done to protect the individual or anyone else.
Yes. You're any further in your thinking through the matter, Member Scott Motley?
No, I'm uncomfortable with it. I'm just uncomfortable with it. I'm tending towards agreeing with the submission that it should be an issue that the purser should determine.
So let us leave it as
in spite of all that you have outlined. I don't.
Yes. So let us set aside that recommendation then.
Yes,
Right.
I would like to reflect on it a little bit more.
All right.
But as I say, it gives me an uncomfortable feeling.
Yes.
Yes.
Yes. I think the wisdom that currently obtains is a better one, but let's move on. Yes?
Yeah. Chair, I have a note here, there was a discussion about the inclusion of the child, where the defendant is a child, for the defendant's welfare, that the provisions of the CCPA, there was a discussion about whether child is to be removed. It's not in the matrix, but I have a note here that it was. That if it's a situation where the child is to be detained for the child's welfare, that it is a matter that is to be referred to the Children's Court, as in keeping with what the CPPA. I don't know if I just have a note. I just bring it to your attention.
We know that at clause 3 we spoke about the question of bail where the defendant is a child, unless otherwise provided, and we know at least in the Gun Court Act we have an unless otherwise provision, is to be determined by the Children's Court in accordance with the Child Care and Protection Act.
Right.
But it doesn't mean, and this is something I'm going to ask a check for, does it mean a total exclusion of the Bail Act and the provisions of the Bail Act?
No, just that the proper judge to consider it.
Right.
Would be the judge of the Children's Court.
But this is not what is conveyed at clause 3.2, because it's not just that it is to be determined by the Children's Court in accordance with the Children's Act, but it seemed to suggest that this act is excluded. Madam CPC, I'm going to ask you to look back at clause 3.2 just to ensure that there is no confusion where the question of bail relates to a defendant who is a child. Because my recollection is not that this act does not apply, but that it's a children's court and the relevant provisions of the Child Care Protection Act should also be applicable, but not an exclusion of the Bail Act. Only in terms of who the deciding official would be. It would be under the Children's Court and any of the relevant provision. I think clause 3.2 may need to be adjusted for clarity.
Madam Chair, we need something from the ministry just confirming what the policy intent is.
In respect of clause 3.2?
Yes, because I think something different was communicated.
I see. Then we will look back at it. Ms.
Yes.
Wilkins, Ms. Simons, please make a note to let us look back at the policy intent in respect of how we provide for the treatment of defendants who are children. I'm clear that the court which has jurisdiction would be the Children's Court in accordance with the Child Care and Protection Act, but I'm a little unclear as to whether we are saying that the provisions here in this law, insofar as they're relevant, would not apply. But I'll ask Team LRD to clarify that. So, right? All right, let's proceed.
Clause 8, and this is, how you pronounce it, Camille Golding. Recommendation. In relation to Section 8, though this section has provisions that acknowledge the importance of technology in combating crime, for example, the defendant wearing an electronic tracking device, in addition to the mundane methods deemed as bail conditions, it is suggested that in an attempt for Jamaica to combat aspects of crime that have plagued the society, such as recidivism, an important condition of bail that should be included is mandatory counseling for repeat offenders. This should be especially forward-thinking for Jamaica, as it would be in line with Jamaica's international obligations under the ICCPR, which Jamaica has ratified. Substantiating provisions. The International Covenant on Civil and Political Rights, Article 10.3. This is substantiated by the Memorandum of Objects and Reasons in the bill, which states that the Bail Act 2000 is being repealed and replaced to address circumstances peculiar to Jamaica.
So I'm compelled to make a general comment. Jamaica is what is regarded as a dualist jurisdiction. It means that when we sign and ratify international instruments, we must take the additional steps of legislating domestically. They do not apply automatically as they do in the other type of jurisdiction, particularly in the European Union, where once you sign the international instrument, there is direct incorporation in the domestic law. I see the wisdom of the counseling, but I don't know if that should be a condition of bail. I don't know if that should be a condition of bail. I'm inclined to think not, though I understand that counseling people away from a certain life and in the direction of another can be helpful. And many of us have benefited from counseling, in good ways.
The term used, offenders, it would be a term indicating a person who has been convicted of an offense more than once, not a person who is before the court for bail to be considered. Right. So I'm thinking the Corrections Act, it may be the better place for the consideration of putting mandatory provisions for counseling.
And next thing you're going to hear that the person must be given the right to choose and must not be mandatorily be subject to counseling. Right, so I think we can agree that the suggestion, well intended as it is, would not be, this is not the place for it.
Okay, so the Jamaica Constabulary Force, did it start on this? No. Recommendation. The following are being proposed for Section 8. Section 8.5. It has D, but I'm thinking that it's an error and it should actually be B, but I'll go ahead and read it.
8.5?
8.5. It says D, but when I look at it, I think it's an error and it was intended to be B.
It's speaking to the curfew provision. So that's B. When they talk about...
Yeah, because there's no D.
No, that's B. Yes.
Yeah. Section 85B allows for a court to require a defendant to whom bail is granted to be subject to a curfew order, requiring the defendant to remain within a specified locality during specified hours. There is, however, no provision which expressly allows for members of the JCF to monitor the movement of defendants who are subject to curfew orders. The only method present in the Act for the monitoring of the movements of defendants is contained in Section 85C by the use of an electronic monitor, which does not apply in many cases. We request that a provision be included which expressly authorizes the police to visit persons who are subject to curfew orders as a method to ensure compliance of the said curfew orders.
I recall when we were discussing this matter, the point was raised that the police really generally do not need permission to investigate whether the law is being upheld, and where a condition of bail is granted is made pursuant to a provision of the law. Monitoring for compliance is part of the general duty. But what the officer had said from practical experience is that the courts sometimes listen to complaints from defendants that police are harassing them, and it appeared to me that it was less about being able to monitor, but how it was done by the officers. You want to express a view on this, Mr. Foreman? I can't hear. We can't hear through the mic, you know.
I concur in your recollection of the discussion.
Yes. Yeah. Yes.
Madam Chair, if I may, I remember the discussion, and now that it's back before me again, I must say that I support what is being asked, because I think basically the JCF is saying to us, help us to do our jobs a little bit more because of the situation that you have mentioned. So I'm inclined actually to agree and support the call that is being made, unless there's a fundamental reason we can't. But in principle, I support it.
Then that would be in the constabulary force orders or the Act itself. Because it wouldn't only be in a specific situation that the officer would want to be able to visit this individual. I could see this being even outside of curfew orders.
I think the request was I think the request was specifically in terms of monitoring people on bail. And I recall when we were interrogating the submission, we were trying to get an understanding as to whether it is how the visits were done. But the presenters had expressed it that it was much wider than that. As I recall, my instinctive thinking was whether it was that concern can be addressed elsewhere. But, Madam CPC, if we were to provide for that request, how would that be provided for in 5B?
I'm not sure how that could be provided for, because it would basically be saying that you're asking for permission to be given in the legislation for the constable to observe a person. Why is permission needed for that? Or to what? To conduct a site visit? I would have to know what is contemplated by monitoring, because the provision already does provide again,
my recollection is that for them to be able to visit the premises to check whether the person is remaining indoors. But maybe when we look on the request in respect of 5C for tampering with the electronic device to be an offense, and I think when we had discussed it, there was pretty much a concurrence that that would be required.
But Madam Chair, in addition, yes. I don't think, if I remember well from the presentation, and just to respond to the comment before you made yours, Madam Chair, it's not about seeking permission. I think what they're looking for is more instructions, right? Because of the fact that when they go to court, quite often it is seen that they're harassing. They want to be able to point to the legislation and say, we are told we need to do this, versus seeking permission to do it.
So it would be along the line that where a condition of bail is the imposition of curfew is imposed as a condition of bail, they who know shall monitor to see whether the condition is being complied with, that particular condition.
That's what my memory.
So generally, a breach of a condition has consequences. The question would be, what would be different about this condition as opposed to any other condition that would require a specific provision? I'm just asking for us to think it through. I'm not saying that it can't be done at all.
Madam Chair, I think, and I'm very lenient to the constabulary with issues like these, because if we can help them to make their job easier, I'm always in support of that. But I think in this instance, while in other places it's also necessary, right now before us we have control of this one. And I think we need to make the changes in this one. And as we sit in each Joint Select Committee looking at pieces of legislation, we make the changes as we go along. But it can't be because it's not done elsewhere, we don't do it in this one. I think we need to start from today to just make the corrections as we go along.
Well, let's see. They say there is no provision which expressly allows for members of the JCF to monitor the movements of the defendant who are subject to curfew orders. The only method present in the Act is for the monitoring of the movement of defendants in 5C by the use of an electronic monitoring, which does not apply in many cases. We request that a provision be included which expressly authorizes the police to visit persons who are subject to curfew orders as a method to ensure compliance in the said curfew orders. So let's see why a provision like that may be necessary, if at all. Mr. Foreman, help me think it through here. So we guarantee a right to privacy around the home. So let's see. Privacy of the home, right? Of every person to respect for and protection of private and family life and privacy of the home. Should we consider it then authorizing that they can be visited to ensure that they are staying indoors? Because that's what the curfew order is, that you are to remain indoors for certain hours.
It's up. They're asking for a power to enable them to ensure that this specific condition is being complied with.
Yes. And maybe that's
I'm trying to work through the language myself.
Maybe that's where the difficulty arises, because when they were saying that the courts had expressed some concern in the absence of any provision of law, specific provision of law.
My recollection as well was that Senator Sinclair, I think, spoke of some of his experiences in court where those types of allegations have come up, and it sounded to me more
Or
along
the
the
whole.
lines of excessive
Yes.
monitoring, or whatever word is appropriate to use. Again, rather than a difficulty with the attempt to ensure that a particular provision of bail was being observed. It might be something.
You see,
to
this is a condition that can only be imposed by the court. It's one of the. So,
Madam Chair,
yes.
would it help if in 5B there was a provision included to enable the court to give such directions as it
Yes.
comes to
There you go.
the
That's why you are the
police to
CPC.
monitor
That's
those
why you are the CPC, Madam CPC. Yes, I think that to enable the court to make such a provision, to modify that provision, the same 5B, where the court now would be empowered to authorize the officer to make the check. Yes, I think that would be the better approach.
And that might help to address privacy type
Absolutely.
concerns.
Absolutely.
Judicial officer.
Yes.
Making the specific prescriptions.
That's right. So we will go with the suggestion. We will accept the recommendation and go with the suggestion along the line you have indicated. So we would ask you to draft something and then come back for the committee to consider. All right. And I think in respect of C, we had agreed that we had fallen short and that an offense for tampering with the electronic device would be necessary. So we would accept that recommendation also.
What would be the proposed penalty?
We would have to look. Okay. We would have to determine that. Remember, penalties are not determined in isolation.
No, I was
from other
thinking that
things.
the drafter would...
I'm going to ask the LRD to look at that with a proposal. Right, Ms. Simons? Only because I saw the furrowing of your brows. I picked on you. All right.
We were discussing it.
So the recommendation is accepted, and the LRD is we were to look on appropriate sentence.
Mm-hmm. Justifying. Cornwall Bar Association. Observations, concerns, queries. As it relates to Section 8.5, in light of this, it is likely that the constitutionality of this provision can be challenged and will be argued as not being reasonably justified in a free and democratic society.
Electronic monitoring? 8.5?
Yes. No.
Curfew?
It's two things.
Surrender the travel documents?
It's the surrender of the travel documents, and it's the imposition of the curfew.
And the wearing of the electronic.
Yes, right. All three.
Yes. So travel documents currently exist in the law, surrender of the documents. Yes. Right. And curfew also exists because I know the courts regularly impose them, whether specifically or under any other condition. Yeah. What is new is the electronic provision, but I also know that in meetings of the Justice Council, it was felt that electronic monitoring could be done. And the Justice Council is a forum that facilitates dialogue between the judiciary and the executive on matters relating to justice. that it could be done within this current context, but a specific enactment would be better to deal with it. Yes. And it was also one of the recommendations coming out of the committee. Yes, that review.
I was trying to remember that. I vaguely recall.
It's a specific recommendation. I think the committee was led by former judge.
By the former director of legal reform.
Beyond that, there was another committee when this part of the work was in the Ministry of Justice. We had looked at it. Yes.
The last committee I recall was in 2015, and that was Mr. Bailey. Bail review?
Somehow I'm recalling something else, but it's unimportant right now. A recommendation was made after review. Just hear the concerns, the observations, and the queries from the Cornwall Bar.
It is also opined that putting forward such a provision may be contrary to the current interests of the public and wider society, as we see that there has been recent and arduous movement towards protecting the sharing and processing of the individual's personal data, and be seen as contradicting to the progressive movement of data protection. It is also undeniable that the social climate at this time reveals a prevalence of fraud, malicious sharing of data, and breaches in data security. It is on this basis that it is put forward that this provision be removed at this time.
Can you tell me what the regulations around the travel documents? Because I know this is not the first time concerns. The current Bail Act, just remind me what the regs are around the surrendering of travel documents. Because I remember being very much alive and well in the criminal justice system when those concerns were raised and the regulations addressed to them. I hope my recollection is not faulty.
Don't know where.
No? You have the regulations to the Bail Act there? Just pull them up online, the regulations to the Bail Act. I know many people don't know that the regulations actually exist, but they do exist.
The release of travel documents.
Yes.
Provision. A person who surrenders his travel documents to the court under Section 63A of the Act may apply to the court for permission to travel and for the release of his travel documents for the purpose of such travel. A court may grant an application made under paragraph 1 if it thinks fit, having regard to other circumstances, including whether the person is likely to flee the jurisdiction of the court or surrender to custody, and subject to such conditions as appear to the court to be necessary to ensure that the person A, surrenders to custody, B, does not commit an offense while on bail, and C, does not interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or any other person. I mean, there are a few other subsections, and is there a specific one you wanted? Or?
No, just let us look on them generally. Right.
Subsection
because
3,
I know that they were promulgated as safeguard when numerous concerns were raised at the time around the treatment of documents once surrendered and any hardship that resulted to a defendant who may need to travel. And so the regulations were promulgated to address those concerns.
Yes. Paragraph 3, a person who makes an application under paragraph 1 shall furnish the court with such information as to the purpose of travel departure and return dates, and such other information as the court may require in order to determine whether the permission should be granted. 4, a receipt shall be issued in respect of any travel document.
That's the part I was getting.
Surrendered to the court, and any receipt so issued shall be returned in exchange for the release of the document, provided that where the receipt cannot be produced, the document may be released by an officer of the court, if such officer is satisfied that the person receiving the document is the holder thereof, and the person by his signature acknowledges that he receives the document. 5, an application under this regulation shall be supported by an affidavit deposed by the applicant. 6, where a travel document surrendered to the court by any person cannot be located after its surrender, that person shall be entitled to recover, free of charge, from the ministry having responsibility for passports, a replacement of the travel document. 7, where a travel document surrendered to the court is lost through the negligence of any person, the ministry referred to in paragraph 6 shall be entitled to recover from such person the cost of replacing the travel document.
Was the Minister of National Security and Justice at the time combined?
Yes. This is 2001.
Yeah.
These regs are 2001.
Right.
I don't know what the remaining.
No, remember at the time, Justice and National Security were one. But just to say that the concerns around these concerns are not new concerns. Also, the security features of the passport to guard against fraudulent replication, those have changed, and we now have the MRVs, machine-readable MRPs, machine-readable visas. So at the time, they were all manually written, if I am recalling. I don't think we had fully transitioned to it. And this is not to say any system is foolproof. But we do have data protection law, and when the act is rolled out, there will have to be established all of what is set out in the law. But undeniable that the social climate at this time reveals a prevalence of fraud, malicious sharing of data, and breaches of data security. On this basis, that it is put forward that the provision be removed. Are they saying that there is no place where someone is deemed to be a flight risk for the surrender of travel documents?
Seems to be more of a focus on the tracking device when you look at the rationale, Chair.
Well, it didn't disaggregate it, eh? Yes. All right. But yes, well, the tracking device is to be prescribed and specified. And this is part of the policy, and this is part of the innovation of the law. It's highly unlikely that that recommendation would be accepted when part of the reform of the Bail Act is also to bring it up to standard and to include a provision like this. Anyone feels strongly on it? If not, we move on. If I hear no acceptance of it, then we can say that it's not accepted. All right.
Let me just read the rationale.
Yes.
The wearing of a traffic device facilitates the transmitting or sharing of personal data of the individual, which may have particularly adverse effects on his right to privacy if allowed. For the first time in 2011, Jamaica recognized the right to privacy in the Charter of Fundamental Rights and Freedoms of the Constitution explicitly. Though the scope and content of the right has not been definitively interpreted by the local courts yet, we have seen the rise of the importance of this right in the movement towards codifying legislation to protect personal data of the public from being shared. This is evidenced by the recent passing of the Data Protection Act.
So I am as vigilant about the right to privacy. I've come to accept that in this age of technology, you're going to know because we're all under surveillance and we give away the right so much by clicking on the many things that we click on. The real issue is what you can do with it. But the whole essence of the electronic monitoring is really to know where you are. So there is an inherent conflict in that, because on the one hand, you're saying, don't put them in prison, don't keep them behind bars. You can effectively monitor them by tracking, and then you are hearing, but you're tracking them and you're invading their privacy. Yes, Mr. Foreman.
So I would only add that the broader concept of bail is balancing two competing interests. One is the interest in the person's being at liberty because there's been no conclusion on the offence for which they have been alleged to have committed. And then on the other side of it is that any condition of bail will involve some limitation on a right. If there's a curfew, it's a limitation on liberty.
And
it's surrendering a
movement.
passport, it's
Yes.
a limitation on
Yes.
movement and so on, which is particularly why these specific types of conditions should be judicially
Imposed by a judicial officer.
Right. So that's and
that is the
put the burden on
safeguard.
the
That's
judicial
the safeguard we
officer to
build
balance.
into the
Right.
legislation. Yes. There seems to be no appetite to accept it, so we can move on.
So not accepted.
Yes.
Clause 9. Norma Manley Law School. Observations, concerns, queries. The following are made for Section 9. Section 9.1 imposes an impractical and onerous limitation requiring that an application to vary conditions of bail must be made to the deciding official who granted the bail. It is impractical and onerous because of a number of reasons. The trajectory of criminal matters before the courts generally, when the court is seized of the matter, police and JPs should have no further say, and the same matter can go before many different judges during its lifetime. Furthermore, matters triable in the higher courts spend only a limited time in the lower courts where the conditions were attached. Section 9.3 is vague and ambiguous, and it does not state with clarity who is the subject of the provision. The use of the phrase offense concerned does not assist, especially as Section 9.4 uses the phrase a defendant who has been charged with or convicted of an offense in direct contrast.
Madam CPC, would you want to, especially with the last 2 points?
Not really, Chair. I don't really see anything. I'm not really understanding what the basis of the comment is because I'm not seeing any ambiguity in referring to a defendant in relation to the offense concerned. Is it not understood that this is the offense in relation to which that defendant is denied bail? And 4 deals again, generally with a defendant who has been charged or convicted. So I'm not sure what the basis of the confusion is.
So 9.1 says a defendant who is granted bail shall surrender to custody. 2 says where a deciding official has granted bail, the deciding official may, on application by the defendant to whom such bail is granted, or the prosecution or a constable vary the conditions of bail. I think the question they're saying is that if it's the police who granted it, should it be the same policeman? What if the policeman is transferred? If the bail was granted by the JP, should it be the same JP? If it were granted by the court, should it be the same judge? I think that's what I glean it to be saying. And if that is so, I can understand, because I think the intent was that we would have it done at the same level. Now, if possible, it can be the varying of the conditions can be done by the same category of deciding official, but it may require a little clarity just to understand that it is a category of deciding official as opposed to the specific person. I think that's where I see the concern. Does it mean that I have to go before the same JP or the same judge when they may be assigned other place?
So we could change the "the" to "a." Well, no, I leave that for the draft.
Madam CPC, right. Let's see how we could make that a little clearer, so that it's not felt that the legislation is saying you must go to the same person. What if the police officer is no longer around, has been promoted up? What if the judge is transferred, etc.?
Well, I think that needs some deeper reflection, because, again, one doesn't want any deciding official shopping to take place. So I think there would need to be some further instruction on how a case where the same deciding official is not available, how that is to be treated.
In other circumstances, I think we have used the word "as far as is practicable," something to that effect. I think we have that in somewhere. But please reflect on it, because, I mean, it is true that you don't want the shopping to take place with the varying, but it is a reality that it may not be the same judge who has that court list on which that case is listed. And it doesn't prevent the judge, or even when you make an application to vary, it doesn't necessarily have to go before the same judge. Because right now, at the parish court level, you have more than one judges in the parish, and even in the Supreme Court. Though I hear the Chief Justice saying that judges will be assigned over an extended period to their courts, etc. But I can see the concern about the appreciate the concern raised. All right, so let's just set it aside for the further consideration and guarding against the risk that you identified.
Sorry, and just to be clear, the variation here is not the same as an appeal against a decision.
No. Right. So, and this happens routinely in the court. For example, linking the previous provision where the person is asked to report, a condition of bail is that you report 3 times a week. Say someone has gotten a job or it has become impractical, they may apply to the court and say, can it be varied to 2 times, 1 time? Can the times for reporting be varied? So that happens routinely and are not matters that are prejudicial in any way. And even if it is not the same court that grant it, the court hearing the application would have to consider on the merit of what is presented. So what is the reason that it was granted? And remember, you hear from both sides. What is the reason? The only time a court doesn't hear from both sides, if it is making an application in favor of the person. And we have lots of case law. But the moment you're going to make, and a variation is going to be adverse to one side and favorable to the other in any way. So you would have to hear it out. But I would say, do give it further consideration to see how we can make it clear that it's not precluding the matter going before the same category of deciding official, because we don't want real administrative problems.
Sorry, the same category.
A police, for example,
right,
or a JP.
Same category and the same person who decided the original condition?
Well, I believe that is a concern raised by the Norman Manley Law School, that their interpretation of the provision is that an application to vary a condition of bail would have to go before the same person who had imposed the condition in the first place,
but
and it
the
may
policy,
be impractical.
But the
policy was to keep it at the level, not necessarily. So
it can be the same person, it can be the same category of person.
Yes, it can be either the same person or the same category, whichever is practical. It's not intended to create a hardship on persons, and it's certainly not intended to be impractical and unworkable. So that if you come upon a court where they say, judge is not here, judge has been transferred to Clarendon, you have a dilemma. We have had that case, and I need to check whether it's the same thing. You know the rule which says that you need an order in order to get an indictment in the parish court, and the judge who grants the order must be the judge that tried the matter. And if that is not so, the trial results in a nullity. There is that very technical rule. And when I was on the bench, I would say to clerks of court in training them that do not ask for the order ahead of time. Ask for the order the moment you are proceeding to trial, because that technical rule, you can run into trouble. Because, trials were nullified on that very technical rule. So I think it is not the intent that if the particular judge or particular police is not available, then someone within that same category of deciding official can't hear the application to vary.
And sorry, one last question. Is it a ranking? So you go to the same person,
I don't
and then
know.
If not the same person, the same category, and then maybe if not the same category.
Let's look back on the
higher.
concern that has been raised by the law school and see. So they say that Section 9.1 imposes an impractical and onerous limitation requiring that an application to vary condition of bail must be made to the deciding official who granted the bail. It is impractical and onerous because of a number of reasons. The trajectory of criminal matters before the criminal court generally, when the court is seized of the matter, the police and the JPs should have no further say, and the same matter can go before many different judges during its lifetime. Furthermore, matters triable in the higher courts spend only a limited time in the lower courts where the conditions were attached. So that's their first concern. And then in respect of 3, they say it is vague and ambiguous. It does not state with clarity who is the subject of the provision. I don't understand, but it is the defendant who is denied bail. Who else would be the subject of that provision but the defendant who is denied bail? And that is what is stated in the opening words. Where a defendant is denied bail in relation to the offense concerned, the defendant may make a new application for bail at any time. Madam CPC, the words "the offense concerned," where they are placed, is that the place for it, or where they are denied bail, they may make an application for bail in relation to the offense concerned at any subsequent hearing? Would harm be done to reposition the words "in relation to the offense concerned"?
Yes, Chair, I think it is actually less ambiguous where it is right now, because you're talking about the denial of bail in respect of a particular offense. So to move it even further away from the subject, which is the denial of the bail, I think would just make it...
Would it clarify a little to say "in relation to a particular offense" instead of "the offense concerned"?
Well, I think it's tighter when you speak about the offense concern, because if you say you would have to then repeat that. if you were, just to make it clear that you were not talking about a different offense.
All right.
Because
May I just ask for further reflection on it to see if there is any way?
I can reflect, but
yes.
I don't think there's a difficulty in the way it's expressed.
Yes, I know. I don't think the difficulty is for us. For us, it's easy to see because of our own training and expertise. But when I read one, for example, and I looked on the concern, when I read one, it was easily understood for me. But when the concern was raised about the practicality, it was also understandable for me, given my experience in the court. So sometimes, what seems very clear to us, people's experience with it is a lot different. So just look back and see if there's any way the clarity around the policy intent can be improved. All right. So we can move to 10, no?
Clause 10, recording and giving information on decision concerning bail. Camille Golding. The following are being proposed for Section 10. It is suggested in Section 10.1, the word surety be included to indicate that the surety should also receive a record of the decision, considering that that is done in practice in the courts. This is especially important where the surety's independence is at stake as much as that of the accused person. In Section 10.4,
I don't have any harm.
Sorry.
I don't see any harm with that. Anybody who's impacted by the decision should really get a copy of the decision, eh?
Yes.
Yes, because responsibilities flow. So
that is accepted.
We could accept this, yes.
In Section 10.4, where mention is made of the defendant's representative, is reference being made to the defendant's attorney or surety? It is suggested that that has not been made clear.
Let's see, 10.4 says a deciding official who's required under subsection 3 to give reasons for a decision shall note those reasons in the prescribed record and shall cause a copy of that note to be served on the prosecution and on the defendant concerned or on the defendant's representative. So it does cover the attorney or any other person who represents. Wouldn't you say? If it any thought on that?
Madam Chair, the term defendant's representative, wouldn't that be the attorney? Or is there some other meaning?
Let me just check something here. Well, I was just checking what was provided for in terms of the right of someone to represent themselves, but the entitlement is to defend oneself or through legal representation of your own choosing, or if you don't have sufficient means to be given such assistance as is required in the interest of justice. So what we're saying is that the record is to be served on the parties involved or directly or on the representatives of the party. Should we specify attorney? I think leaving it the defendant's representative would be wider and would enable somebody else to also get it, and it doesn't preclude the attorney who is clearly a representative. That is what I would say. the ambiguity there inure to the benefit of the defendant. Any concurring view? Remember, if you're concurring, nodding is not, does
I
not
concur.
go on the record.
I concur, Madam Chair.
Yes, Mr. Foreman, you were nodding away, but when you don't go through the mic, it's not recorded.
I concur.
Yes.
Jamaicans for Justice. Recommendation. It has been recommended to amend Section 10.4 to say, a deciding official who is required under subsection 3 to give reasons for a decision shall note those reasons in the prescribed record and shall cause a copy of that note to be served on the prosecution and on the defendant concerned or on the defendant's representative within 24 hours after the decision is made. Rationale. JFJ remains concerned with the increased time in which oversight for those unable to take up bail is provided. On the back of cases such as Noel Chambers, there is an avenue for those who are most vulnerable to end up in long-term custody with their case never being considered. Provisions such as Section 11.3 should aim to mitigate issues that may cause tragic outcomes like Chambers to occur. One of the issues affecting the Chambers case was the lack of oversight when considering his reasons for detention.
Oversight was to be done by whom in Chambers' case? My recollection was by the courts. So that happened in the judicial branch. And I just wonder, imagine it is...
But that includes in the definition of deciding official.
Right. I'm just saying that, remember, it is to the judicial branch that we go to seek remedies for delay. And the thing is here. I'm very sensitive to the recommendation for specifying time within which action is to be taken. The one caveat I have is that when you specify a legal burden, liability flow from that in a worst case scenario. And if, for example, you have so many matters in a given day requiring bail, even though we are now moving to the form, a clerk, a judge may be in court for the entire day, very little time afterwards. Look at how, in our effort to get things done here, we are here for the entire working day, then we go in traffic. You're required to do things. So you kind of have to strike a right balance on what would be a reasonable time after the hearing of a matter in a case where we have simplified the form in which decisions are to be recorded to ensure that the records are transmitted. I am sympathetic that there should be a time set. Just want to make sure that it is realistic. And I'm also sympathetic to the view that the person on whom a burden is imposed to create the record should be held to account within the time frame, because your business is really getting it done. But, we have a paucity of resource. So, I don't know what is the view of members. I think 24 hours is a little long, just a little short, just because you may have so many matters and it's the same clerk who is assigned to then get it before the judge, and a judge is moving from one place to the next, etc. But I am inclined to set a time frame. And when we set this time frame, it doesn't mean it can't be done in a shorter time. And it is my hope that public officers and civil servants will understand that if we say 24 hours, if you can do it in 3 hours, do it in 3 hours. If we say 48 hours and you can do it in 24 hours or 12 hours, do it in 12 hours, unless you have good reason to stretch it to the outer limit. So we could consider a time frame, since there are prescribed forms in which the record should be made. What do you think would be a reasonable time?
I seem to recall in a discussion about turnaround time for another reason. I think it was...
Because remember, you know,
there was
the officials are not creating the record from scratch. That's why we have gone to prescribe records.
There was a concern, though, that 24 hours in the case that were a similar type situation, that it...
Impractical.
There were situations where it just wasn't possible.
Think of it for the work that you do. Even if you turn around something, the kind of pressure it puts, you sit from one meeting to the next, and everyone is requiring you to turn it around in 24 hours. And you need time to review, you need time to... So it's about striking the right balance. And part of the education of the deciding officials at all levels is to ensure that you don't put off for tomorrow what can be done today. You get it out as, you know, cultivating a new culture of respect for others. But I think 24 hours would be impractical. I would say within a 48 to 24, 48, 72, which would allow, say, between a Monday and a Friday. That would be an outer. That would be what, a 72 hours? Two, 4, 6, 4, 3 is 12, 72 is 3. Madam CPC, I know this would be a matter of policy, but that recommendation could be accommodated to indicate a time frame within which you could just put in square bracket and we would take some decision on the time within which the decision is to be communicated. Let's not deliberate on it here.
Chair, what is being recommended is a shorter time than 48, you know. They're saying we have 48, and they're saying it should be 24. But in our
let
view,
me just hold on.
So we think we could leave 48.
Hold on. 10, it's at 10:1 or 10:4?
10:4.
I think it's fine. For a moment there, I thought the time had not been specified. That's why I was saying, oh, no. And I recall our deliberating to make it as short as possible, but not to ensure that it can't be done.
Exactly.
Yeah, so that we would keep what we have.
All right, Norman Manley Law School. There is a lack of clarity in the appeals process for matters covered both by Section 10.3 and 11. Section 11 matters are a subset of Section 10 matters, and therefore a defendant with a Section 11 matter has access to the court under both Sections 10 and 11. Furthermore, it appears that the review court also has simultaneously the power to hear a renewed application under Section 9.3. Inconsistent listing of the powers of the judge / deciding official in Sections 10.1. This does not include affirm. Section 10.3. This does not include confirm / affirm or revoke. Section 11.4, this includes affirm in contracts to 10.3, and 12.7, this includes affirm but does not include revoke or impose.
All right, Madam CPC, can you look at that and say, because the powers that are granted in dealing with review and appeal, the recommendation is to amend 11.3. A judge of the court shall at least once per week. No, that's not it. Norman Manley Law School. The recommendation, Section 11 matters have 3 conditions precedent, require for review, application for review must be done by the court having jurisdiction to try the offense. It must be done on first appearance of the defendant before the court, and the applicant must fulfill a condition under 11.2. The submission is that the review process serves very little utility and can readily be excluded without any loss of provision. Well, the intention was that where bail is granted out of court, on the first appearance in court, for the judge to quickly look at the matter to see whether the conditions of bail granted are properly granted, and to see if any change need to be made between the time when bail was granted and the person coming before the court. Many things can happen. I'm not sure I'm appreciating the rationale that it serves little utility and can be readily excluded. I don't know what's the view of others. But that's a safeguard, that where the bail is granted out of court, upon the person coming before the court, a review is to be done. That's a proper safeguard. Right. I'm not appreciating the remark, but I do, I would ask that the provisions at 10, 1, 3, 11, 4 be checked for consistency or inconsistency if the intention is to confer the same set of powers on the deciding official. Madam CPC, you can either look now quickly or we can look later and come back.
10.3 didn't refer to the grant of bail because it's a duty to give reasons. So that usually only arises where it's an adverse finding. Or
sorry, I didn't hear you. Could you just repeat that?
I think the comment mainly was because 10.3, which is the duty to give reasons, didn't refer to the grant of bail as the 10.1. But one would not be giving reasons in that case for the grant of bail. It's usually, that duty is usually imposed where you have an adverse decision, and it's for the purpose of enabling the defendant to appeal.
Remember now that both sides can appeal. So it's not just the defendant who can appeal. What may be favorable to one side is adverse to the other side.
Well, I'm not sure that we
is to allow both sides an opportunity at different stages. So both may apply for variation, both sides, depending on the justice of it. Both sides may appeal.
All right, well, okay, we could add grant or, well, in that case, we don't need to specify or enumerate the different items, because then reasons should be given in respect of every decision. So 3 could simply refer to the giving of reasons for a decision under subsection 4.
The enumeration just assists persons with the kind of decisions that are made. So a decision...
Chair,
yes.
It's not inconsistent.
It's not inconsistent?
No. In case of 10, where you're dealing with the grant in the first place, affirmation is not an issue.
Let's just look at the provisions. So it starts with, okay, not 9.
So 10.1 is the original decision.
10, hold on. I'm just...
So it wouldn't include
all right.
affirm.
There is a lack of clarity in the appeals process, it says. Inconsistent list. Let's start at, there is a lack of clarity in the appeals process for matters covered by both 10.3 and 11. So 10.3 says that where a decided...
No, it starts with 10.1.
10.1.
Because it doesn't include affirm. But it's the original decision.
Hold
so
on.
Affirmation is not an issue.
Hold
it's
on.
the first time a decision is being taken.
Hold on. Let's reason it through. So subject to subsection 2, where a deciding official A grants bail or refuses bail, so it deals with both sides of the equation, appoints a time or place for a defendant who is granted bail to surrender to custody, imposes or varies any condition in respect of bail, or revokes bail, that deciding official shall, in the prescribed form, make a record of the decision and shall cause a copy of the record of the decision to be given to the defendant and the prosecution, or in the case of a defendant who has not yet been charged, to the police, as soon as practicable after the record is made. Then 2 says, where bail is granted to a defendant by endorsing a warrant of arrest, the constable who releases the defendant on bail shall make the record required by subsection 1 instead of the judge or justice of the peace, as the case may be, who issued the warrant. 3 says, where a deciding official refuses bail, imposes conditions in granting bail, varies any condition of bail, or revokes bail, the reasons for the decision shall be given in accordance with subsection 4. Subsection 4 says, a deciding official who is required under subsection 3 to give reasons for a decision shall note those reasons in the prescribed record and shall cause a copy of that note to be served on the prosecution and on the defendant concerned, or on the defendant's representative, within 48 hours after the decision is made. And then 5 says, where a decision referred to in subsection 3 is made in respect of a defendant who is not represented by an attorney at law, the deciding official shall inform the defendant of the procedure for review under section 11 or the right of appeal conferred by section 12, as the case may be.
So affirmation arises in the review or appeal.
Right. So if you're just making the decision, you're not affirming anything.
That's it.
Right.
So I don't think there's an inconsistency.
So let's just see what it says now. It says inconsistent listing of the powers of the judge or the deciding official in sections 1. This does not include affirm. I see, because in section 1, this is where bail is revoked, not where, right, so it's granted or refused for the first time.
Well, yes, so it would have both.
Yes. But the revocation means that there would be an existing condition, but an existing bail. But this provision is dealing with the making of the records. I'm not kind of understanding the powers, what the point of the submission is.
The recording of the decision.
This is a recording of the decision and the circumstance, the kind of decisions and the circumstances in which the record must be kept and the form of the record. So I'm a little lost. Someone help me understand what Norman Manley Law School is saying in this. 12.7. All right, let's look at 11.4 before we jump to 12.7. 11.4 says that on a review under this section, the judge may affirm the decision reviewed, grant or refuse bail to the defendant, impose conditions on bail granted to the defendant, or remove or vary any condition of bail imposed on the defendant. In the case of a review under subsection 1, may revoke bail granted in the I see. So I think you may review it and affirm that the bail stays.
As an outcome of the review.
Yes.
Yeah, but 10 isn't trying to do that.
Right. So is this where they say 10.4, 11.4, this includes affirm in contrast to section 10. Right, but they don't appreciate
so
that this is a
error,
review.
yes, seeing 11 as a subset of 10.
But hold on, but the
problem.
fact that you're revoking the bail, isn't that a review somewhat?
Yes, agreed. It is somewhat of a review.
Right.
But in this case in 10, it is more concerned with the documenting of the decision than it is with the actual.
Right. It's not the power. This is talking about when you take decisions
this is
along those lines.
You formalize it, yes.
Right.
So I don't think 11 is necessarily to be seen as a subset of 10.
And then
They're not doing the same
No,
thing.
and that is speaking to the record taking. Yes.
Yes.
This is speaking to the review of the decision. Two different things being provided
That's
for.
it.
And then at 12.7 now.
That's
12
an-
speaks
that's
to
the
appeal
appeal.
from the decision.
Right.
12.7 says on an appeal, the judge may affirm the decision that is the subject of the appeal, grant or refuse bail to the defendant, or vary or remove. So affirming it, say, if you're not on bail, you stay not on bail. If you're on bail, you stay on bail. Grant or
That's
refuse bail. I guess affirming it would end up with either granting it or refusing it, depending on what decision you're reviewing.
Yes.
And the varying or removing of any condition is
depending on the appeal.
depending on what the ask of the court is.
That's it.
Yes. So they're saying that this includes affirm but does not include revoke. Well, but does not include revoke. But the court wouldn't be revoking in these circumstances, because what the court would do is, depending on who is making the appeal, would either grant it or refuse it. So if the prosecution is making the appeal, that someone on bail should be put in custody. If the court grants the application, it results in the person being remanded. If the person is in custody and makes the application and the court grants it, it means the person would be released on bail. And if the court refuses it, the person stays remanded. I'm not sure how revoke applies there. Madam CPC, you can help me out. You have a better understanding of it.
Well, I don't think there's any harm in including revoke there, since it's one of the decisions that could be appealed by the yes. So
okay, all right. I see. So what we would be doing is to say where bail is revoked, you can appeal that decision to revoke. Is that what you're saying, Madam CPC?
Well, no, the revocation would come in, I would suppose, if the prosecution appeals the grant of bail. So the decision then of the court would be to revoke the grant.
Which provision would...
In 7, in
how would that read?
27. So, on appeal under this section, the judge in chambers may affirm the decision that is the subject of the appeal, or grant or refuse bail to defendant, revoke the grant of bail to defendant, or vary or remove any condition of bail imposed on the defendant.
All right. So we partially accept the NML or partially address the concern by accepting the recommendation to include revoke in 12.7.
By the prosecution. Right, sorry, I was saying that in similarly in 10.3a, we could include words grants or, so you could read grants or refuses bail just to accommodate the possibility of the prosecution.
So both 10.3 you say and 12.7?
Yes, 10.3a to include the grant and 12.7 to refer to revocation.
Okay. All right. 10.
So you're saying that when they grant the bail, they must give a reason why they granted bail as well? Because that's what 10.3 is dealing with. The recording of the reasons for the decision.
Remember,
So
no,
they must say why they granted it.
both sides can appeal.
No, I'm just asking if that's what we want for 10-3.
You're giving reasons for your decision, yes.
Okay.
Yes, reasons are being given for the decision because the law is empowering both sides to either seek review or appeal the decisions, review of or to appeal the decisions.
The recommendation for 12-7 to include revoke, the words here, grant or refuse. We're going to remove grant. I'm going to remove refuse and put revoke instead. Because I don't think we should have both words.
Ms. Wilkins, I would agree that on reasonable interpretation, if the court is to refuse bail, it would include refusal of a bail that is already granted. But just for clarity, I wouldn't oppose including the word revoke.
But then it's okay to have them both?
I would think so, because it would accommodate the case where bail was not granted in the first place, which would then, it would include the case where bail was not granted and an appeal is made for bail to be granted and the court is refusing the application, refusing bail, or a case where bail was granted and the court is now revoking that grant. So to include them both would just put everything beyond doubt.
Okay.
Yes, I get that. All right. All right, we are upon that time of day that you may be a little weary.
We
just
concur. So.
Plus, I think we are at the end of clause 10. I wouldn't want diminishing returns to set in. So this is clause 10, 9, 10. So we would pick up at 11. Okay. So we will continue on page 27. 26? 26. Yes, it's 27. We just completed 26. Yes. Yes, it's 26. The review of the decision. Yes. What is our next day and time again? Just a minute. There's a March 28 whole day, right? Yes. So you would have been notified of the next date and time, and that is Tuesday, March 28 at 10 a.m. Tuesday, March 28 at 10 a.m. All right. I think we have made good progress today. We need to hasten the pace on the next sitting. So the date of the next meeting, and we know it's March 28 and March 30 would be the next set of meetings. All right, so I am reporting progress, or we have gone up to clause 10. And is there any other business that any member wishes to raise before we move for the adjournment of the meeting? No other business? My closing remarks is to thank everyone and to thank the chambers for the opinion provided in respect of the constitutional questions, in particular on the pre-charge regime. And just to reiterate that I didn't expect the opinion from the chambers to say otherwise, because it would mean that we would not have done our work in bringing the provisions here. So we had, in fact, researched the matter, and were of the view that the pre-charge bail regime can be properly accommodated in our constitutional provisions under Section 14. And I thank the Chambers for its extensive 21-page opinion affirming that decision. On that note, date and time of next meeting, as indicated, March 28 at 10 a.m. It's Tuesday. Parliament will sit in the afternoon, and then we have a whole day sitting on March 30. Will someone move for the adjournment?
So moved.
Very well. And seconded by Rodriguez, Campbell Rodriguez, and Charles. Thank you so much. The meeting is hereby adjourned.